2nd of August. Now, during the course of the hearing, the Government Council raised a question regarding the assignment, and His Lordship passed this order. I am giving along with this memo and posted it to 2 weeks. I handed over this to the learned district judge Keunjhar, but he has rejected it and posted it for execution of the decree to 20th of August. May I pray, my lords, most humbly, that the matter may kindly be listed on 20th of August.
No, we don't know who the matter is assigned with whom.
As it arises, Lordship may read that order. I am giving the order. I am placing the order. For second, for Justice of the matters. Yeah, my lord, the question is
All right. I'll file more.
on 20th.
I'll see the file and then I'll decide.
Man, I am saying about the urgency. I may not be misunderstood, man.
No.
May I beg
The
pardon?
memo is, I am giving the memo, man.
May I beg pardon to mention? May I beg pardon to mention, this writ appeal, I pray because the registration DD is the registration DD sub-register denied to the register the document illegally. Then in the honorable for proper for that reason this is the registered DD is yet to be dormant. So I pray to reinstate.
So how is the matter urgent? There are so many matters before us. So
My lord-
why preference should be given to your case?
My lord, registration is yet to be.
Registration, the other person is ready to register. Why should you be worried? Wait for some time. Please wait for some time, make a mention after 2 weeks. All right.
Will I submit the memo?
Huh? No, after 2 weeks, make a mention, we'll see.
My lord, here is a small matter, my lord. Pleadings are complete. Here, my lord, I was being terminated on a misconception of fact. Subsequently, state has reinstated me. This cause of action relates to my back wages. If your lordship pleases, my lord.
So where is your matter?
My lord.
Listed?
Not listed, my lord. I am praying for listing, my lord.
This is WA.
WA, my lord.
WA.
I am deprived of my legitimate service. Any date, my lord, if you ask me.
Huh?
My lord, he was a clerk in the DU office, my lord.
Therefore, not that urgent. All right, give your sleep.
Most of that.
I may be pardoned to mention, your lordship.
Yes.
From the list, your lordship, item 60, it's a contempt matter, your lordship. It will take just 1 minute, your lordship. May place as the last case before rising, your lordship.
Item 60.
Yes, your lordship. As the last case before rising.
Contempt or you are alleging contempt?
No, your lordship, we have filed a compliance affidavit. It was for disposal of a representation. We have already done that. We
On
filed
the
a
other
complaint.
side?
Yes, your lordship.
I shall take instruction, madam. And he has given the now he solved the copy, madam.
Your Lordship, we filed a complaint and it was for disposal of the representation. We've already
Representation
done.
has been disposed of what
Disposed
instruction?
of by the opposite parties.
We will,
One
Party,
opposite
by the
said,
principal, Your Lordship, opposite party number 3.
my MBA certificate was not issued till 4 years or 5 years, my lord, back. But
what was the order?
order was that they consider the representation by the opposite parties.
They have considered.
Within 3 months.
3 months, my lord.
So they have considered, done it after 3
Yes,
years.
Your Lordship, we've also served a copy to the petition.
College considered all the documents sent to the university, my lord. University did not come give the certificate, my lord, till today, my lord.
This
So the
is,
representation, your representation, there was direction for representation. Whenever the court passes such order, you may say that instead of passing this order, your case may be decided this way or that way.
I
So
shall
you got an order for disposal of representation, they have disposed of their representation, your representation.
I shall take instruction from the petitioner, my lord.
What
I will
instruction?
take instruction.
What instruction will you take? He will give you liberty, all right? Give you liberty to challenge that order, all right? All right.
Item number 1.
Your Lordships, the second limb of my argument, which I seek to make, is this, that it's a fact that they did not follow the procedure which they had laid down in their tender notice, and which they say that the list that they have published, the list of rejection and the reasons, are not actually the list of which is conceived by clause 7. But that being the list, our case was that should have given us 3 days time, and the documents which were missing in my case were not any futuristic document, and they were document which could have been provided. They were minor infirmities. Your Lordships, just to show that there were infirmities also as far as the private opposite parties were concerned, may I take Your Lordships first to page 990.
Yes.
Your Lordships will find that report has been signed on 13/2/2021. That's a balance sheet. 13/2/2021. Below, Your Lordships will find that. Bottom of the table also. Whereas it shows that it's a balance sheet up to 31st March 2021.
Yes.
Now, this is a document of, I think, OP number 4, POCT. On the face of it, Your Lordships, and this was an essential document,
Yes.
that the balance sheet of their ultimate manufacturer had to be there on record. So this could not have been considered as a compliance. And precisely for this reason, that 3 days was there. I give my explanation also, and if I have to assert anything against the other people also, I could have. But that's not done there. Then Your Lordships will see, and just to point out the clause also, that Your Lordships will find at page 47.
Yes.
And there is no explanation to this discrepancy by the state. The state only said that we use the UDI number and we have verified it. But you verified exactly what is being shown today. Because you could not have this signed on an earlier date when you're showing us a balance sheet up to March. Normally, balance sheets of big companies are created after March, and normally anybody who's such a big company, their returns are filed by September. Now your lordships will see the another discrepancy was at page number 1057. Only going by the documents, because my rejection was only by the documents.
Yes.
Now your lordship will see 1, 2, 3, 4, fourth point from the bottom. The bed height adjustability range 500 to 900 mm.
107.
157. 1057.
Yes.
So PO City offered ICU bed
Yes.
with a height range of starting from 500 to 900 mm. Now, this is very important, your lordships. Sometimes you need to have the criteria was 450 or below. The reason being, if your lordships have seen that, when there's a heart attack or something, we have to take those measures. The doctor has to be at a certain height to give those measures. So the lower the bed, it is sometimes easier for them. So, your lordships, now the explanation they say, then now we did an inspection and we found it was 450. But the fact is, if all the scrutiny is on base of the document, what you offered was 400, 500, never 450 on your document. This is what your manufacturer is going to supply. So if that is the case, then my discrepancy was only that I had to show that the Berger paint is NABL certified. And that the Puma foam comes with a ISO certificate. Anyways, it comes. So your lordship, what happens is Puma foams are produced and manufactured continuously. So each of them would come with it. These are only two discrepancies. So my case was that had you given that 3 days time, you would have taken a sound decision. You would have looked at the document, sound decision, and there would have been more than one players to justify that. And then, your lordships, as far as SI surgicals are concerned, which is also an opposite party, their balance sheet did not have the UDI number. All the financial documents did not have a UDI number. And they say that in some other document, they found some UDI number and they clarified it. So if you are showing such a wholehearted, clarity for them, making so much, mine wasn't a big infirmity. That's all that I'm trying to say. It could have been. And all that happens is, your lordships, my bid what I have understood is that my bid was competitive financially also. So it was a revenue point also. And all that I'm saying is Puma foam anyways comes with, every Puma foam will come with a certificate. So that they could have seen, you verified it for me, you could have verified it for me also. And if you've done the physical verification, you've done it for everybody. We were also through.
Yes.
That would be all my submission.
My lord, may kind turn to page 950. Annexure 8 series.
Section 8.
Yes.
Yes.
My lord, may I see? This is dated 11/12/2023 bidders selection rejection list. Now, my lord, we can see top second item name is Fowler bed with side rail. Item name is.
You are referring to page?
Page 950.
Yes, we are at 950.
Yes, ma'am. This is dated 11/12/2023. The heading is bidder selection and rejection list.
Selection and rejection list, yes.
And second item, my lord, heading is item name.
So tender name, furniture on rate, then item name.
Yes, item name, Fowler bed with side rail, because this repetition covers 6 items out of 13 items. Well, this is the first item, Fowler bed with side rail. Now the next serial one is list of bidders which are technically responsive. These are OP4 and OP6. The serial one is OP4, serial two is OP6. Then two, list of bidders and their offered items which are technically non-responsive and not qualified. Now, my lord, may kind told to serial 10 at page 951. Page 951, bottom is serial 10. That the petitioner. And what are the grounds of rejection, my lord, may kind see. The submitted salt, spray, chamber test, epoxy powder coating and phosphate coating test report is not from any government or NABL approved lab accredited as per ISO 17025 for quoted item as per bid requirement. And second ground of rejection is bidder has not submitted the IS 7933 standard certificate of PU form from any ISO 17025 and NABL accredited laboratory as per bid requirement. Now, my lord, may kind turn to page 60 of the writ petition. Page 60.
Yes.
My lord, can see clause 6.17. Heading is list of documents in bid submission.
Clause 1.6.17.
6.17. List of documents in bid submission. The list of documents, scanned documents to be uploaded online in PDF format as a part of technical bid part 1 is as mentioned below. Now 6.so. Now, my lord, can do page 61. Well, we are concerned with 6.17.17.
Yes.
Copy of quality certificates valid AERB, BIS, CE, USFDA, IEC, and IESO. My lord, may kindly mark IESO of the product organization as per section 7 technical specification. So this is a requirement that these documents have to be submitted along with the technical bit. Now, my lord, may kind turn to page 86. What is section 7? Page 86. Section 7 technical specifications.
Yes.
Now, next page, my lord, can see page 87. My lord, can see the heading. General requirement for all furniture items. Because these are items which we procure for different government medical college, because we are not using all those items which are to be procured by this tender. We'll procure on behalf of the different government medical institutions, and after procurement from different vendors, we will supply to the different medical companies. As on that, there are 4 medical colleges where the infrastructures are made ready for operational. Because of non-supply, because of the pendants of the writ petition, we are not in a position to procure all these items, as a result of which these indoor units that ICU have not been made operational because of non-supply of the furniture item.
The court is to be blamed.
No, I am not saying.
You are right.
Today morning I have
Because
received.
of the pendency of the writ
No,
petition.
in the meantime, all these
in
infrastructure.
order, because whatever you have done is correct, but because the writ petition remained pending, therefore you could not do it. So did you make any application for vacating the interim order?
No, I have not.
Why?
Well, because the pleadings were not complete, so that's why.
Pleadings, because the order was parte, you could have filed.
Yes.
There are 2 applications.
I have filed.
They had filed. So you cannot make this submission.
No, no,
You should be, your department should be ashamed of it. All right,
Page 87, my lord.
all right. So her submission is very simple,
Yes.
that there were two defects pointed out, which she could have satisfied, the petitioner could have satisfied by submitting certificates within 3 days.
Yes, my lord.
So why was that not done?
My lord may kind on to that clause. My lord, if my lord permit, I can place all those grounds of rejection. Thereafter, I will come to that.
No, there are only two grounds of rejection.
Yes. Because these are the two documents I am driving my lords to those clauses, well, whether that is a mandatory requirement or not. And if
That
the
may be mandatory requirement,
yes,
but whether her submission is correct to the extent
yes,
that she could have satisfied that the certificates were there.
well, there is no such provision to submit an additional document after the technical bids are opened. There is no such provision.
No, but what is that 3 days?
Not even 7.
No,
Because 7 says,
your lordship may kind on to clause 7.
seven is at 3:45. No, sorry.
Yes, okay.
Page 45, my lord, kinds. Page 45. May I please? Any representation or suggestions must be received within 3 working days after the pre-bid meeting. Well, here this thing has happened, but the person has not submitted any representation within 3 working days after the pre-bid meeting.
Or
That
within,
or
or within,
within 3 working days after publication of provisional selection rejection. Well, here this provisional list has not been followed,
provisional list has not been
not been
published.
published.
Or have been allowed.
And my lord,
Oh,
can say,
that pre-bid meeting must have been to remove doubts.
yes,
But
my-
this could have been for removal of defects, but that provisional selection list has not
Not
been
been-
published.
well, what is our response, my lord? May kind turn to my reply to
Just
resent.
a minute. So we are on clause 7 at page 45.
Yes, ma'am.
So whether any pre-bid meeting was held or not.
Yes,
Pre-bid meeting was held.
yes, ma'am. That was held on,
By the time the bid has not been examined. That is denying doubts. about
Yes,
something.
yes, pre-bid meeting is.
Yes. Second one.
Then it
has
says, after publication of provisional selection rejection list.
it has not been done.
Why?
Final list was published.
Yes, final list was,
Why? Why was this not done?
because of urgency in procurement.
Urgency,
That
the reason you are violating your own terms.
Which is that clause that pertains to publication of provisional selection list? No, no.
So then,
Regarding doubts.
No,
There must be a clause saying-
seven.
Yes. Proceedings. So there must be one clause saying that provisional solution list will be published thereafter. You can realize that thereafter having this something like that.
May I submit? Or within 3 working days after publication.
my explanation,
All right,
my,
so this is not mandatory.
yes, my lord, may kindly see
All right.
paragraph 5 of my reply to regender. Well, my answer to this clause. Paragraph 5 of my reply to,
My reply to rejoinder had it not been raised in the writ petition,
yes, that was,
but you
Raised.
did not reply.
no, it was replied, but it has been better clarified in paragraph 5. Reply to regender by OP number 2 and 3.
That you would have told us instead of making us read 6.184, whatever it is. 6.1.0.
Yes.
Paragraph 5, my lord, we can say sub-paragraph of paragraph 5. It starts with under clause 7. Under clause 7 of section 4 of the bid document, tendering authority has the option to receive the representation suggestion either within 3 working days after the pre-bid meeting or within 3 days.
That we have seen, that is apparent from the
Yes,
clause itself.
That is quoted in page 3, 6.18.4. Which page is that clause in?
yes, I'm
Page 62
62.
and also 6.18.
We'll see 6.8.
1.8.
1.8 is that thing.
Page 62.
Both the clauses are at page 60.
All right.
You are relying on 6.18.4.
6.18.4 also and 6.18 also.
The second 6.18. They have
6 point-
two 6.18.
Yes, and the bold 6.18, which says also after the opening of the technical bid, you get that 7 days period also. Whereas they opened the financial bid the very next day.
So this was not followed.
This was not followed. So we did not know who has given what. Everything became very evident only when that list came out.
6.18.4. Second part, however, minor infirmities in the submission of documents will be allowed to be rectified.
That is why I was placing page 87. Thereafter, I would clarify this, whether this is applicable.
Clarify that
Yes.
it is, you want to say it is not minor.
Yes, it is not a minor. That is why I am placing.
So if without stating that, why are you placing so many things? You first said it is not minor, which is apparent from so and so page. Otherwise, we are wondering why you are showing us page after page.
No, that is why yes, I may be wrong. Well, this is a substantial error. Well, this is a mandatory requirement that the petitioner should submit the NABL certificate. Well, there are 2 clauses which requires that these 2 certificates have to be submitted mandatorily along with the technical bid. And failure to submit those documents entails rejection in accordance with clause 16.18.4 first part. But there are 2 parts. In case of substantial error, the bid has to be rejected.
Why do you say it is substantial?
That is why I am placing, my lord, may kind on to page 86. I was placing that. This is section 7, technical specifications of all these products. Page 86. That is in bold.
Yes, 86.
Yes, section 7, technical specifications.
86 is only the
Yes,
opening
then
page.
next page, page 87, heading, my lord, we can see general requirement for all furniture items.
Yes.
Next page, my lord, we can see page 88.
Completed, no. Page 87 E. List details
A,
is
B,
to be
no.
complied mandatorily.
Yes, for the present situation, A, B, C, D, E, these are not required.
Or then mandatorily is not required already.
No, these documents are what is required at page 88, my lord, can I say, bottom. Mandate must come from any government approved laboratory or NABL accredited laboratory which are accredited as per ISO 17025 for test procedure like impact test, bend test, salt spray, chamber test, epoxy powder coating and phosphate coating for coated item. Copy of previous test report should be furnished in technical bid as well as during supply. In-house test report of the manufacturer will not be considered. Then clause 11, same page. For mattresses and items where PU foam is used, the manufacturer of PU foam should comply to IS 7933 standard from any ISO 17025 and NABL accredited lab. So these are the mandatory requirements that it has to be submitted along with the technical bid.
Where is it that it has to be submitted along with the,
I have placed that clause, my lord, at page 60. List of documents in bid submission. Clause 6.17, the clause 6.17.17. Copy of quality certificate so and so as per section 7. So quality certificates have been mentioned at page 88.
At page 88.
Yes, my lord. Bottom, product and manufacturer quality standards. We are
So where
concerned,
does it say that these should be mandatorily supplied at the time of technical bid?
clause 6.17.17 at page 61.
6 point?
17.17 at page 61.
list of documents to be uploaded online as a part of the technical bid?
Hmm. 6.17 provide that copy of quality certificates valid so and so ISO is there of the product organization as per section 7 technical specification.
What's the heading? 6.1 to 60.
Page 60, the list
Wait, tell 6.17, then 17.
17.17.
First,
Page 60 and 61.
that list of documents is here mentioned below. And 17 mentions that certificate. You're not reading the main part. 6.1719 below that.
Yes, a copy of all the above
Where I
documents.
mentioned that in your reply to rejoinder.
This has not been submitted.
Anyway,
Copy of the order of documents below 6.17.
one second. Honor the opening of the new failing which the bid shall be rejected. This is the main thing that he is not working about. Making us read so many things, it is clearly stated there.
No. Well, it's provided a copy of all the above documents uploaded in the technical bid shall also be submitted along with the original EMD and tender cost as mentioned in section 3 by post courier on or before the opening of technical, failing which the bid shall be rejected. Well, initially they will upload in the online. Well, those hard copies along with the EMD, original of EMD and tender cost, they have to submit the hard copies within the stipulated period.
First, online.
Online.
And
Therefore,
before the opening of technical bid, also hard copies.
hard copy.
So that also I think not done
No,
because
since he has not uploaded in the online, so he has not submitted the hard copy.
Only after rejection came to know that those are not there.
Yes.
It is a mistake, but
And this is the mandatory requirement. And now my lord can see his rejoinder, he has admitted that he has not submitted.
copy of, no, that they're not denying. He's saying that 3 days time which you didn't give because he was in possession of those documents. It is not that the documents came into possession after the date.
In a similar situation, my lord,
You have
No,
three decisions.
your submission can be that because of this provision,
yes,
you did not have any option but to reject it.
yes, that is my submission.
Because that is the requirement of the
Tender,
notice.
yes,
Says that it shall be rejected
yes.
if it is not uploaded.
In that case, that shall be considered.
Hmm.
Oh, it makes it clear. The last line makes it further, clarifies it further.
Hmm.
That these documents, it is not that if you have not supplied, you cannot give. It is stated these documents must be supplied for better clarity. But only if the scanned copy
Uploaded.
has been uploaded earlier. So this is your main.
Yes. And all, my argument will be in respect of all items, same violation and same argument will be, same clauses are relevant.
Hard copy.
And in a the next item also, my lord, page 953.
No, for whatever you have rejected is only because the documents were not there.
Yes, yes. Because these are the mandatory requirements which are not, and the documents which submitted along with the representation under Annex 9, well, that cannot be taken into consideration in the absence of any clause thereof. Because my lord, will
No,
kindly.
you have kept two clauses, but you have not followed. You have kept two clauses, but
No.
this appears to be mandatory because those clauses relate
Yes.
to minor defects.
Yes. Then 16.18, my lord, will kindly say, well, that has also not application, no application to the present case. Page 62 bottom, my lord, will kindly see. Page 62 bottom. Heading is notice to bidder. Bidders shall submit any query or observation or representation on uploaded technical bids within 7 days of opening of technical bid. Well, once she has not submitted the document online by uploading the same, so what is the question of submission of any representation? Well, each her grievance is
No, no, that is because you have that clause. So she has complied with that clause.
no on uploaded document. Well, on those documents which have been uploaded, well, he can submit the clarification. Well, not in respect of an additional document. You can say the word is uploaded technical bids.
A technical bid, not documents.
Wording, no,
Where?
just before uploaded.
Where?
Second line of clause 6.18.
Yes, uploaded technical bids.
Yes, he has not submitted this
Technical
NABL.
bid he has submitted, you have rejected.
No, NABL document
Where is
certificate.
NABL written there?
No, that is the requirement. I have placed those
That is
clauses.
different. This is different. That is different.
Yes. And in a similar situation, hello, the petitioner was having a document, he submit an expired document along with the bid. Well, that entailed rejection of the matter ultimately came to the approach, came before the Honorable Apex Court. Apex Court held that,
Expired document, valid document, there's a difference.
no, he was having that valid document, but he did not.
Had given the expired document.
Yes. I will place, though there are 5 judgments, I will place only that. I don't know, serial 2.
Yes.
AIR 2011 Supreme Court 2574.
Yes.
Paragraph 6. The question for decision in this case is whether on account of the corrigendum whereby the provisions of section 3 of the tender documents and section 7 of the bidder's checklist were amended, the appellant was disqualified from consideration in view of the fact that along with the tender documents it had filed through inadvertence or otherwise a copy of the ISO
Which
900
paragraph you are reading?
paragraph 6, internal
Page three.
page numbers are at bottom right hand side.
Yes.
Page numbers are at the bottom.
Question.
Which paragraph you are reading?
Paragraph 6, first paragraph at the top of the page.
The question of
Yes,
decision.
the question for decision in this case is whether on account of the corrigendum whereby the provisions of section 3 of the tender documents and section 7 of the bidder's checklist were amended, the appellant was disqualified from consideration in view of the fact that although the tender documents it had filed through inadvertence or otherwise a copy of the ISO 9001-2000 certificate of the previous year instead of the current year, although it did have the said valid ISO 9001-2000 certificate at the time of making the bid. The case of the appellant depends almost entirely on the submission that on the date of submission of the bid, it had a valid and active ISO 9001-2000 certification, but that through inadvertence, the expired certification of the previous year had been filed along with the bid papers. Now, my lord, may kind turn to paragraph 32. After discussion and page 9, bottom is the page number. Having considered the submissions made on behalf of the respective parties, we are inclined to accept the submissions made by the Attorney General that the introduction of the corrigendum completely changed the provision in the bidder's response form relating to submission of the quality certificate in the form of an active ISO 9001-2000 certification. In any event, the appellant's contention based on clause 9 of section 7.1.1 of the RFP as it stood prior to
Yes,
corrigendum
paragraph 33.
32, my lord, sir. 32, I'm
33.
30,
32, 33.
32 and 33, yes,
Yes, that's the only submission.
yes. And all these
So
documents,
what is your response to the submissions
Yes.
that there were defects in his bid also?
yes, that I have clarified in my counter affidavit, my lord, my kind. Because all those requirements, there, my lord, my kind, to the requirements which they have to submit in a proper format, my lord, kind, page 117.
Yes.
Page 117. Well, that is the format of annual turnover statement.
Yes.
To that allegation I have dealt with in my counter affidavit. Paragraph 13 of my counter, internal page 16, my lord.
Yes.
That the averments made in paragraph 10 of the writ petition are misconceived and not tenable. It is submitted that the bidder, Messrs. POCT Services, that is OP number 4, has submitted the format T8 annual turnover statement by chartered accountant for manufacturer in compliance with clause 5.2.17 and 5.2.24 of the section 5 of the bid document. The figures reflected in the annual turnover statement under format T8 as well as UDIN reflected therein were verified and found to be correct. Hence, the contrary allegations being reversed. Now, my lord, can do page 59 of the counter. Well, that is the document which was submitted in the proper format.
Yes. We will see. Yes, do you have to make any submission?
I am for the opposite part number 4 and 6. In respect of opposite part number 6, he has selected in respect of one item, parlor bed man.
You are for 4 and 6.
6 man. In respect of 6, there is no allegation in the writ petition man.
Yes.
In respect of 4, they have stated 2 allegations has been made relating non-mentioning of UDIN number that is there in the document filed by the petitioner also, and relating to submission of the bid in respect of ICU bed, the height adjust is 500 to 900. The allegation is you have stated 500 to 900, which is not correct. Your Lordship, in the counter affidavit, I have mentioned this same thing. Your Lordship may see page same page. My lord, page 1051. When page 1051 of my bid document in the read petition, this same thing I have filed with my counter affidavit. Serial number 16, my lord. Bed height adjustment rate should be 450 mm or less than 700 mm. I have categorically stated, my lord. What happened, my lord? Initially, the advertisement has been made. The tender document shows the bed height should have been within 500 mm to 900 mm. Thereafter, they change it. So by that time, the leaflets and other things has been prepared. And inadvertently, though we have the format we have stated correctly, but inadvertently in the leaflet it has been stated relating to 500 to 900. But in format as 1051 we have submitted, that has been mentioned that 450 or less than 700 mm or more. And the authorities have considered all the tenderers in that aspect, because for the first time they have called for the tender by stating 500 to 900 mm. Thereafter they have changed it. If there is any deviation, they have called for all the tenderers. I have also given the demonstration of the ICU bed on my own cost. And other documents I have filed, Your Lordship, the allegation in the writ petition has been made at page 20 against opposite partner 4.
Yes,
A chart has been prepared by the petitioner.
yes.
The bidder has submitted financial report. No UDI number has been mentioned, my lord. That is the allegation. But UDI number has been mentioned in the, as my lord and friend has shown. Everything has been mentioned in the in the format, and in the first page it has been clearly mentioned about the UDI number also. Apart from that, the minor infirmities are allowed to cure, because my lord and friend has shown that date has been wrongly placed. Instead of 31, it has been stated 13. It is available in the website, because we have filed our return in the website. That has been verified thereafter. Not that we have filed the document thereafter. The same document is available in the website also. When the signature has been put, it has been wrongly, instead of 31, it has been put 13 by the chartered accountant. And these minor discrepancies, which is available in the website, that has been cured. And I am the successful bidder in this case, my lord. I have submitted my security deposit, everything I have submitted. I have stated in the counter affidavit, my lord. I have given the reply of my lord, I have mentioned in my counter affidavit para
Everything is
7
there
and
on, everything is there in the pleading.
yes, my lord.
Our pleadings and your pleading in your.
And what one submission may I make, my lord? I should not make that submission. Whatever my learned friend has submitted in respect of additional documents, those documents relating to the certificate obtained from Berger Pants are not at all acceptable, my lord. Even if it is accepted by the authority, it is not a certificate of that person, because that is a certificate, an certificate issued in respect of Berger Pants relating to the pants.
That is-
Here you should take a certificate after painting the pants. Thereafter you should take a certificate, my lord, for yourself.
Have you given a certificate in
Yes,
that?
yes, I have given everything.
not-
I'm just asking, your certificate.
Whatever
is
he
in
has
Yes, yes,
submitted
what
right
order
now
you
is
are
not
Yes.
there in the pleading. So all, just one thing I will not
No,
take a lot of
let
time.
me complete one. There are two judgments I
budget-
will place. But thereafter, my learned friend can. My learned
I
can
think that one judgment covers it. I will not dispute with that judgment. Only thing I wanted to clarify fact is the certificate was there. That the epoxy certificate was there. The salt certificate was there. All that we had missed out to show that Berger Paints laboratory is enable. That all that is not there. So if they could have taken the effort to clarify it from the UDI number for them, they could have also seen that Berger is, and Berger is a big name, your lordships. But what Mr. Das
That is
submitted
not
is
enough.
not there
Big name
on
is
the
not
pleading.
enough. Yes.
My lord, may kindly serial number 1 of my memo of citation. That matter came from this honorable court. My lord, what was happened, my lord, the unsuccessful party challenged the award in favor of the successful party before this honorable court. Well, after roving inquiry, this honorable court allowed the writ petition by setting aside the work awarded in favor of the petitioner before the honorable appeals court. Now, well, after hearing, my lord, the scope of judicial review has been laid down. And that is two.
Yes, this is a very famous case, Mr. Jagdish Mandal.
Yes.
We will see.
The same Tata Cellular
Then serial number
observations
5.
which have been
Then serial number 5.
reflected there.
That is
Yes.
2022. Well, there all those judgments have been taken note of, and they are also scope of judicial review has also been laid down.
We will also take note of this.
Because there also, even if there is some error in the decision making process, so the honorable court should not interfere.
I do understand, your lordships, ultimately they've laid down the test of public interest. And that's why we said that we had a very good financial bid, because their financial bid is open, ours is there. And that's it, this discrepancy was a minor discrepancy according to our submissions. Okay. So if we had come in, they would have a lot of revenue.
Maybe that
saving on
aspect.
But your lordships, I leave it to your lordships' wisdom on that.
Cannot go in.
Wrong officer.
And as we had pointed out, as it was only documentary, what they actually things would have been clear had they really published the technical bits. That
Oh.
6.18 they did not follow. We did not know who was doing what.
No, 6.8, they had alternative, 1 and 2, this or that.
No, 6.18 they totally did not follow. That technical bit should have been everybody's technical bit should have been available to be seen. No, they gave it to us when we filed this litigation, a little before the litigation. That they did not follow. Except clause 7 they did not follow. Probably the mess would have been less had they followed what they had set the standards for them.
Yes.
But I know, understand, public interest would be the ultimate judgment of the whole thing. Oh, bless you.
Applied.
Ms. Rath, in a lighter vein, I don't know what we'll decide ultimately. But in case you lose, you'll be on the same footing as Mr. Harish Salve. So you take consolation from that. That's the golden case.
Oh,
Same-
bless you,
same
bless
point.
you, that.
I mean, at decision, I don't know
Certificate has
what
been
way.
given by my lord friend in page number 1247. There it has been mentioned relating to the
I
column,
was reading
not
now-
that relating to.
I was reading an article by the senior Nariman where he said, when you are given this gown, you're actually put into soup to do difficult work. So I somehow now realized that.
Okay, question to me, I have denied for that.
So this is on the retaining its position. If possible, we will deliver judgment or we can dictate judgment. We'll decide on that.
Okay. Okay.
Oh, bless you.
Raise admission item number 2. My lord, I have received as per lordship direction, I have received the amount from the department, but the writ appeal copy has not served on me.
Sir, on,
I'll serve.
uh, counsel representing the respondent has received the amount of cost which was condition precedent for condonation of delay in preferring the present appeal. So Let a copy of the writ appeal be served upon the counsel for the respondent by and counsel for the appellant in course of the day.
In course.
So when do you want?
My lord, the matter may be adjourned for 2 weeks.
I requested on behalf of the respondent, this matter on 2 weeks.
You're Mr. Swai?
Yes,
Item number 3.
This is in respect of that Narsu Pradhan case. The Lordship have posted all the batch of matters to 22/8. So let this matter be listed on that.
Around 22/8. Notices have been issued.
Yes, my lord. Here the delay has been condoned.
Other side has appeared.
Other side has not appeared.
It has come up for fresh admission
Yes, my lord.
after condonation of delay.
After condonation of delay, and in fact, delay was
So-
condoned because on that day also nobody appeared.
Yes, exactly.
Yes.
That is why fresh admission. Otherwise you would have asked.
Or else your lordship may issue the notice. To issue the notice.
Either way.
Item number 4.
4 weeks. Just 6 weeks.
Item 4.
Met. Input order at page 20.
What about limitation?
Limitation,
Condoned?
yes,
Condone, your lords.
limitation condon, my one friend has appeared.
Yes, what is the matter about?
The
You
matter-
have received a copy of the
Yes,
writ
yes,
appeal.
sir. Yes, your lords.
Writ appeal you have received?
Yes.
All right. So what is the order?
At page 20, man.
Yes.
May I draw my lord's to this page 61, that operative portions? Then page 61. May I read? In terms of rules 1990 as quoted above, if there is a ward which is minor and who alone is available in the family of the deceased government employee for employment, she shall apply for job under the said rules on attaining the age of 18 years and in no case beyond 3 years from the date of attaining the age of 18 years. Admittedly, as per the certificate issued by the doctor, the mother of the petitioner is suffering from chronic disease like type 2 DM, diabetes mellitus, and hypertension and heart disease, and she was physically and mentally unfit to work as an employee under the rehabilitation assistance scheme. Hence, the petition applied for consideration of her application in terms of the said rules 1996, July 2013. That is after she attained the age of 18 years, and that was well within 3 years from the period of limitation prescribed in the rules 1990. Her application in view of the stand taken in the counter and argument advanced by the London State Council would have been rejected on the ground of delay or on the ground of availability of the spouse of the deceased government employee. Further, the authenticity of the medical certificate was never disproved by or competence of the doctor to issue such a certificate was never questioned by the authority concerned. Rather, petitioner's application dated 6/7/2013 was processed. Even for the sake of argument, it is accepted that a period of is submitted by the Learning Council for the state as 1 year, there being a provision under the amended rules 2010
For condemnation of delay, the application of the petitioner being certified by the collector along with all formalities was reported to the concerned authority with a recommendation to condone the delay if any in terms of the said amendment rules 2010. Thereafter, the said application was forwarded by the concerned authority to the government to be placed before the committee for consideration of the case of petition under rules 1990. Being directed by this court in WPC number so and so, the appointment number 5 superintendent intimated that her case is under active consideration. Immediately thereafter, that is on 18/1/2000, the impugned order was passed after about 3.5 years on the ground as stated above. So far as judgment cited by Mr. Patnaik and the counsel for the state, this court is of the view that the facts and circumstances of the said case are different from the present case and are not applicable to the case of the petitioner to debar or to seek for an appointment under the rules 1990.
Yes.
But this is the case. I'm placing my two dates. 28/9/2006. The father of the petitioner died.
28.
9/2006, my lord.
Yeah. Yes.
Then my lord, next date 3/7/2013.
Yes.
6/7/2013. The respondent filed an application for appointment under rehabilitation assistance scheme.
Yes.
It is admitted fact as on the date of death, that is on 28/9/2006, the age of the mother was 40 years and the age of the respondent was below 18 years.
Yes.
Admitted fact, respondent was minor as on the date of death of her father. The rule says
Yes. So when did he attain the age of 18 years?
in 2012.
Yeah.
LSMS rule, Odisha Rehabilitation Assistance Rules 1990. Rule 9. Application for appointment under these rules. Well, Rule 9.
Yes.
Rule 9(6), Your Lordship.
Yes.
Application for appointment under these rules shall be considered if it is received within 1 year from the date of death of government servant. Then, my lord, 7. If at the time of death of government servant, there is ward who is minor and who alone is available, but that ward is who alone is available in the family of the deceased government servant for employment, he or she shall apply for job under this on attaining the age of 18 years. Admitted fact, as on the 2006, when the father died, mother was available and she was 40 years.
But this petitioner, respondent is the only child or
This
Only
is the daughter.
only child?
Yes. That rule says, I am reading again, my lord. If at the time of death of there is a ward who is minor and who alone is available, here Rule 2B. Family members shall mean and include the following members in order of preference. There my wife or husband, son, so and so, so and so. Even in order of preference, wife comes first. Despite that preference is not applicable, if both can apply, that I don't dispute that. But admitted fact, as on the date of death, mother was available. It was admitted fact, as on the date of death, this respondent was a minor. And the rule says one had to apply within 1 year. What has happened in this case? Mother did not apply. After 7 years, he filed an affidavit that I am ill, my daughter may be provided with appointment. Even not in the year 2007 or 6, she has filed an application, I am ill, I cannot be appointed or not attaining the age of majority, my daughter can apply. But after 7 years, she filed an affidavit, I am ill.
No, but whether on the date when her husband died, she was suffering from such ailments.
No, madam, there is no document to that. I'm submitting that. For the first time, he submitted the document on 28/6/2013.
May have submitted the document, but does the document show that she was ailing since then?
No, your lordship may see that is the document he has annexed. Your lordship. That in that read petition, he has annexed that document. Your lordship may see page 13 of that read petition. Let's look at it, page 13, the read petition. Sorry. Group D. Group D. No, my lord, that instruction I have to take, my lord. I cannot. That is not mentioned elsewhere, that.
Illiterate, my lord.
Your wife is, your mother is
Mother is illiterate.
literate.
My lord.
Literate or illiterate?
Illiterate.
Signature kochi.
Where is her sign or LTI? Let us see.
Page 12 of the read
Right.
petition.
That means just able to cite it. That's- My lord. The
Which provision?
under the rehabilitation assistance scheme, your lordship, the application submitted by the petitioner, read petitioner, before the authority concerned should have been rejected on the threshold on the first time, because rather the application of the petition has been accepted by the authority concerned and a delay has been condoned by the authority. Your lordship, may I file an written notes of argument, written notes of on page 23, your lordship.
One can condone the delay.
And
But also there is no provision for condonation or delay. It is not a limitation.
manner. Rather, the application has been submitted after 5 years of the submission of the application, where this honorable court. And
This situation also. And this is allowed to happen. When every old person in the family, old being not of the age of superannuation, will wait for son or daughter to attain the age of majority.
Yes.
So that he may have longer period, longer tenure of service. So had he been appointed, he would have retired after 20 years. Now, if he is appointed today, after receiving his, he is appointed, then he may continue for 43 years. So why not this? And see the genuineness of certificate. We can get this inquired into at this stage, whether the certificate is genuine or not given by the doctor. What kind of certificate is it? You don't have even a chit of paper of any medical prescription.
while the matter was stood before the honorable single judge, this honorable was directed to the Lorraine Government Council to verify the certificate. After that, the order was passed to your lordship.
What verify? There is prescription. There is, do you have any prescription? Any medical prescription?
Medical certificate was given before the.
No, certificate is fine because regarding prescription that you are under medication for diabetes and hypertension,
IHD, we don't know, and then eyesight issue. And then he certifies that he is not fit for a job. Who is the doctor? Certified. License could be cancelled.
if the authority should have been rejected the application on the threshold, Your Lordship.
Therefore, they are to be bound to appoint.
No, Your Lordship, application was admitted after 5 years of the submission of application. Therefore, the order, after the order passed by this honorable court, they suddenly rejected the application on the ground that this.
You should not be there for filing your application 6 years or 7 years after the death of the employee. All right, you are then named for not rejecting the application immediately thereafter, and you can blame the court also where this writ appeal is pending since 2019.
In that,
There is nothing wrong with you, but everything is wrong with every other person, other institution or what proof do you have that you are suffering?
Also, my mother has filed an affidavit before the authority concerned, before the collector, that I am physically unfit.
Affidavit is fine, but supported by what document?
See, this affidavit would have been filed in 2013. Yes. 2006. That yes, I am available, but she is minor and she is alone who can be appointed after she attended the age of majority. I think not. After 7 years, you are maybe.
The rehabilitation assistant appointment, Your Lordship, the read petitioner will only daughter, the very distress condition of the.
What distress? You could survive for 7 years. You could survive for 7 years. And you were critically ill, but nothing happened to your mother.
Only one document, Your Lordship, kindly see. On page 23 of my death chart, Your Lordship. The certificate issued by the collector. Only one document, Your Lordship, kindly say. On page 23.
We can, in this case, we can carve out an exception. Say that.
Yes.
Hold that you are not there, but you are not there.
Well. Item number 5.
Item number 5, Your Lordship, Mr. Mishra, he has some medical difficulties, Your Lordship, can you take it next week, Your Lordship, I pray, Your Lordship, can next.
No, I am for the appellant here,
I am for the respondent.
Any interim order?
No interim order because only limitation has been condemned on 24/7/2024.
Item number 6.
Obliged.
Stress of contempt. Have you filed any contempt application?
No,
Same matter, your lordship has decided the similar issue
some bench matters are there.
that promotion during pendency of vigilance case.
Obliged.
Item 6.
May I please? Here the petitioner, my lord. Challenge the order of the single judge order annex 7. I am permitted the place paras 6, my lord. Running piece 171, man. Having had the learning counsel for the parties and after going through the materials available on record, this court find that the appeal in the question in appeal number 1 by 2021 was disposed of by and 7 and a 7 running page 171 para 6 mile. The relevant two portion, last portion of the two paragraph.
6.
Mile. Para 6 mile. Having had learning counsel for the parties and after going through the materials and available record, this court find that the appeal in question, appeal number 1, 2021 was disposed by the Honorable Minister by order number 16 for 2022 by answer 25. As found from the annex D by 1 to the counter, department, not exalt department, is a deputed file petition for 11/5/2023 seeking review, recall of the order dated 16 for 2023, that is after 13 months, taking into account of the submission made by the government advocate that impugned or notice has been issued with regard to the hearing of the application for review, recall the order 16 for 2022, so filed with the department on 11/5/22 under annex D by 1. This court is not inclined to accept the submission of the Lord and Counsel for the petitioner that such a notice has issued for hearing the appeal. Next one. Para 6.1. It's on page 172. In view of such position, which is apparent on the face of record, this court is not inclined to interpret the notice so issued to the petitioner under 88/2023, annex 28 to the writ petition, and according to this court, while disposing the writ petition, that the petition to appear before the Honorable Minister for consideration of application, so filed department for review oblique recall order 16 for 2022 under annex D1 to counter. Opposite part number 1, he directed to issue process notice to petitioner for hearing the petition so filed under answer D1. Man. My humble submission, no notice to the appellant, my lord. Even if arguing for the sake of argument, not considering thereby, even review can never be filed lower authority, even if authority by the more than 6 months as per rule 32 of the OCS section 962 mile. That relevant. Rule 32 mile. The authority to which appeal in an order of imposing any of the penalties specified in Rule 13 lies may on its own motion or otherwise call for the records for the of a case in a disciplinary proceeding, review any order passed in such a case, and after consultation of the commission over class 2 employees concerned, where such consultation is necessary, for such orders as it deems fit as if the government servant has preferred an appeal against.
Oh, tomorrow holiday. अच्छा 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 और नहीं
I am putting. My parent place rule 32 of the OCS.
Yes.
I am parent place the rule 32 of Odisha Civil Service, CC rule 1962 mile. Again.
Yes.
32. Review of order of disciplinary cases
The authority to which appeal against an order imposing any of the penalties specified in Rule 13 lies may, of its own motion or otherwise, call for the records of the case in a dispute. Order passed, my lords. That is 16/4/2022. 16/4/2022. Okay. That is 11/5/2023. That is 6 months. There, the proviso, my lord, Rule 32 proviso, my lord, provided that no action, my lord. My lord.
And 11/5/2022 and.
22, no. 11/5/23, my lord. 11/5/23, my lord. For detail.
And appeal. Signed by the applicant. Under the procedure of OPSCC.
Sorry, my lord, that rule is not applicable. Right? The CC rule, lordship, is that OCS CC rule is applicable in respect of government employees. Here it's not a government, that has not been, your lordship is that 32.
Who are you?
Sikha Sahib, my lord.
Sikha Sahib,
Sikha Sahib.
My lord was hearing that yesterday's matter, where the initial recruitment of 419 posts, then subsequently 15,000 posts without advertisement were filled up. They were given appointment. The same matter. It is the same matter.
I'm sorry.
and that 30, your lordship, for moment, your lordship is that rule 32.
OCA CCS rule is not applicable.
That is, my lord, all contractual applicable CC rule is applicable, my lord. By virtue of contract, they have added the CC rule, my lord.
He must have been imposed with a punishment.
In my lord, appeal, my lord, proper to my lord friend, my lord, Rule 23, my lord. Appeal against the order, government servant may appeal. I mean, being holder of civil post, my lord, being appointed by, selected by government, appointed by government. So after they have
Her appointment is engagement.
this is my
And for a moment, your lordship, my learned friend is saying that he has a preferred appeal. Your lordship, for a moment, your lordship, page 40 of his appeal. Whether he has appealed, preferred appeal under Rule 23 or not. Page 40, my
9/5.
annex. Page 40.
Page
40, my lord, of the writ appeal.
appeal.
That this appeal he has preferred. And this is not an appeal under Rule 23.
So it is similar. All of them are.
Yes,
Yesterday, what we were
yes, your lordship has
considering.
already dismissed.
The matter and the impugned order, if your lordship will see the impugned order, the appeal pending before the minister, there he received a notice.
no notice to me. My humble submission, no notice. Appellant
That
no
was
notice.
challenged by the petitioner along with one Pranabandhu Nag in the writ petition before this honorable court. Honorable court didn't interfere, directed them to participate in the appeal proceeding. Now, in the appeal proceeding, minister recalled his own order. Then the principal secretary has passed the regent speaking order. So this, even this,
my humble
the order
submission.
passed by the single judge has been worked out.
My humble
So if
submission,
he is
no
aggrieved,
notice to
then he has
petitioner,
to.
no hearing by the honorable minister. After election, there is no notice by the hearing by the honorable minister. Is there any notice?
Oh,
I
whether
will be mad.
after 19.
Notice was challenged by him only before the honorable
Madam?
single judge. Lordship may kindly see the order. The notice issued by the minister was challenged by the petitioner before the honorable single judge along with one Pranabandhu Nag. Your Lordship may kindly see the
Pranabandhu Nag-
first title of
First
the
title,
order.
half page is written that challenging the
Notice was
letter
issued
of
to
the
Pranabandhu Nag, not to petitioner, madam.
and others.
Madam, 52.
If it was notice
Madam,
issued to Pranabandhu Naik, why were you challenging it?
because no notice was to issued me
So
to
you
me.
are challenging
So
the
that is
notice.
my prayer, my lord, that judgment of the honorable minister was accepted. So far, my petition is concerned. His appellant is concerned. Appellant judgment was not neither challenged in the appeal and not for hearing or review petition. I have declared a prayer that my judgment passed by honorable minister is accepted. No, only notice was issued to Pranam Nag. Only one petitioner. That is my humble submission. Even present appellant, no notice issued. Even after judgment of the honorable single judge, no notice issued. After that election came, after election, no notice by honorable minister. Let my learned friend file counter affidavit. But subject to only notice issued by Pranam Nag. Till that, no notice to the petitioner, appellant, other appellants, 51 appellant, 52 appellant case before the Honorable High Court. Honorable High Court directed. It was
Mr. Counsel,
well,
have attempted to mislead this person. Right. This writ petition was filed by Pranabandhu Nag, and you all,
well,
amongst others. According to you, no notice was given to you.
well.
Why did you file the writ petition?
I filed because no notice to me, and that judgment of the Honorable High Court will the deputy director.
Sir, can you make this submission? Because whether your experience at the bar
Well,
and permit you to make this submission that because no notice was issued, you became petitioner, and because notice was issued, he challenged the notice. If according to you, no notice was issued and the order of the appellate authority was accepted, then why did you come to this court?
because my humble submission,
You won't have no submission. Oh, want to generate litigation? Then enjoy the luxury. Appellate. I put to charge. Order dated 19/2024. WPC number 26198 of 2017. This petition was filed by one Pranabandhu Nag. And how many persons?
Two.
Person.
Writ petition by
total previously filed 52 persons. Before the honorable single judge, only 2 persons. Pranam Nag notice was issued to Pranam Nag and a present appellant.
Pranabandhu Nag and the petitioner. Prayer to set aside that notice.
Dated 8/8/2023. Whereby the thereby the notice and whereby the notice was asked to appear before the Minister of Food and Mass Education for hearing of appeal number 1 of 2021 was put to challenge. So challenge was on the ground that the minister and disposed of the appeal on 6/4/2022 and 22 thereafter it became function of appeal and had no jurisdiction to rehear. So, certain single judge, after having examined the submissions and all on behalf of the parties, declined to interfere with the said notice and dispose of the writ petition, directing the petitioner, Ratified Death, to appear before the minister for consideration of his application filed by the department for review / recall of the order dated 16/4/2022. So next, the applicant was working as
Shiksha sir.
a Shiksha priority. Next, when counsel for the appellant has made two peculiar submissions. So, firstly, he has drawn our attention to Rule 32 of the OCS CCA Rules 1962 to contain that the minister and an appellate authority could not recall that review, could not initiate an action for recall / review of an order passed as an appellate authority after 6 months after passing of the order. So, he has secondly submitted that no notice was issued to the appellate, and such notice was issued only to petition number 1 of WPC number 26198 of 2023. That is Pranav Bandhu Nar. In response to a query made by this court as to why had he joined in the writ proceeding challenging the said notice proceeding with Pranav Bandhu Nar, in challenging the notice dated 8/8/2023, that counsel for the petitioner has made another peculiar submission that he had joined him because no notice was issued to him by the minister. So he has submitted that and no notice was issued to the petitioner, the order passed by the minister dated 16/4/2022 has attained finality as so far as the same related to this appellate. So, this the appropriate permission advanced on behalf of the petitioner to lack coherence, appellate lack coherence. So, the lack coherence, Rule 32 of OCS CCA Rules 1962 shall not apply in the present type of the circumstances of the case, as it was not an order passed by the appellate authority. It was not an order passed under Rule 20 of the OCS CCA rules,
And your lordship may
Okay.
say that 13, punishment import under rule 13. That is only 32 in box there. This is not an appeal. Your lordship may, for a moment, your lordship may see that rule 32. 32, my lord.
13 is a punishment chapter.
13 is the punishment chapter.
Rule 29 is a power of appellate authority. Rule 29. Nine. 29.
23 is the.
29.
Yes, ma'am.
23 is the appeal, the power of appeal. And 29 is power of appellate authority.
Yes.
Of the review in relation to imposition of any of the penalty.
As specified under rule 13.
13 of. Then we do not find any reason to interfere with the executive order. Or it is open for the appellant to appear before the minister.
In the meantime, that review, that order has been recalled and another order has been passed by the school.
No notice, ma'am. I am no notice to. Without notice.
We have been informed that the final order has been passed by the minister.
Minister and subsequently principal secretary has also passed. Commissioner, secretary.
No hearing by minister, no order.
Current counsel is waiting on behalf of the appellant states that the said order has been passed without any notice to the appellant. So it can be at liberty to take steps. The said order is before authority as part of the forum, which is sort of the law. We cannot find it to get into this field for the public. We are of the view that we are of the opinion that in view of the submissions advanced on behalf of the appellant, the appeal deserves to be dismissed with cause. So however, we are refraining from doing so.
Item number 7.
Well, the present appellant filed an application before the Lok Adalat for partition of the joint family property, my lord. And the learned judge Lok Adalat, that's may turn to Annexure 3, my lord. Annexure 3 starts from page 26.
You find.
I filed.
How could you find? What is this permanent and continuous both?
Well, the nomenclature is that permanent and continuous Lok Adalat, my lord. That is under section 19, they entertained it. And under section 21, they passed the decree.
There cannot be a Lok Adalat which is permanent and continuous both. These are two different concepts altogether. And permanent Lok Adalat has some jurisdiction which continuous Lok Adalat does not have.
My lord.
Yes, so you filed application.
I filed an application, my lord. And lordship on to Annexure 3, my lord. It was entertained on 17th February 2024.
That's very clear Whether your application was before permanent lok adalat or continuous lok adalat. Whether your application was before a lok adalat constituted under section 22B or under other provisions of legal service party act.
It was filed before the permanent and continuous lok adalat, my lord. Under section, appears to be under section 19.
Just
All right, let us see.
Madam.
See, permanent lok adalat does not have the jurisdiction to entertain such application,
Madam.
which was filed by you.
Madam.
So forget permanent lok adalat. Let us examine the scope of the jurisdiction of continuous lok adalat. What is there? And there is no continuous lok adalat.
Yes, ma'am.
Lok adalat is lok adalat. It's a different matter that where is the provision for filing an application before lok adalat?
Section 22, my lord.
Section 22,
22.
section 22A.
22A.
Very good. Now section 22A read. Permanent lok adalat means what?
Permanent lok adalat means a permanent lok adalat established under subsection 1 of section 22B.
Established under.
Made of permanent lok adalats. Notwithstanding anything contained in section 19, the central authority or as the case may be.
Where are you reading?
22.
Please read what we are asking you to read. 22A.
Yes, my lord. 22A. In this chapter, definitions, in this chapter,
Permanent lok adalat means a permanent lok
lok
adalat.
adalat established.
Just a minute.
Right.
Under subsection 1 or subsection 2B. And this
utility services.
utility services. So it is confined to utility services.
My lord.
How can permanent lok adalat decide your partition application? So you are challenging which order?
I am challenging the order under Annex 1. My lord.
So what has been done?
My lord, my application was entertained by the permanent lok adalat and
Should not have been entertained. Should not have been entertained.
and decree was passed on the basis.
No. It's all illegal. Null and void.
Single judge is learned single judge is directed for approaching the civil court.
Yes, absolutely correct.
They have made a ground of fraud, my lord. The opposite party number 1.
Yes, everything is fraudulent. Right from the beginning. You could not have, you got it done. You could not have the right, you got it done through this, whatever it is called.
May I pray one thing, my lord? Let's simply call on this matter day after tomorrow.
No question of day after tomorrow.
Because here fraud is not proved, my lord.
Fraud is proved. You could not have approached. Why did you go to continuous lok adalat? Under which provision? So patent fraud.
I will examine that part, my lord. Let's only allow one thing, my lord.
When was the order passed?
That is at Annex 3, starts from page 27, my lord.
Huh?
The page 27.
Date.
Order dated 23/2/2024.
No, these should be removed.
Registered on 17/2, this was of.
Should be removed. How are they entertaining? Judge permanent lok adalat. Which place?
Kendrapada. Basis of a compromise is disposed of.
He cannot.
This is utility.
Cannot. The appellant in the presented application as put to challenge an order dated 5/7/2024 passed by a learned single judge in WPC number 10330 of 2024. That's all. In the said writ petition, the respondents had put to challenge an award dated 23/2/2024 passed in PNC case number 65 of 2024 and the consequential order dated 22/3/2024 passed by the learned judge, permanent and continuous Lok Adalat, Kendrapada. Full stop. The said award and the consequential order were passed by on application filed by these appellants before permanent and continuous Lok Adalat, Kendrapada for Kendrapada for obtaining a decree of partition based on compromise. Full stop. It was after you had filed the writ petition.
No.
The writ petition was filed by you.
By the respondents, present respondents.
By the respondent. In the writ petition, the respondents alleged commission of fraud on the part of the appellant in obtaining the decree. Stop. Considering the nature of allegation, the writ proceeding, and the fact to the effect that the compromise had been obtained clandestinely by one of the parties, the learned single judge, setting aside the award and the order passed by the judge permanent and continuous Lok Adalat, is granted liberty to approach civil court for obtaining a decree. Next, learned counsel appearing on behalf of the appellant has argued that a decree passed by permanent Lok Adalat / continuous Lok Adalat based on compromise ought not to have been set aside by the learned single judge. So stop. Yes, further submitted that there was no fraud played by the appellant as was alleged by the respondents herein. And therefore, the order deserves, order passed by the learned single judge deserves interference.
The website also says that here.
Let's say, may take note of section 19 subsection 5 also. Let's say, may take note of section 19 subsection 5.
Yes.
It may.
Mr. Counsel, can you show us any provision under which you can go to the Lok Adalat directly?
No, Miller, there is not.
How the matters go to the Lok Adalat?
They approach directly, Miller.
Who?
The present appellant approves
Court
directly.
referred,
Yes.
court refers, court may refer.
Here court has not referred, Miller.
19 refers to holding of Lok Adalats by the court.
Again. Lok Adalat shall have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of any case pending before.
First, go to paragraph 1.
Every state authority. Here they approach directly.
Next, learn. Counsel appearing on behalf of the appellant has not been able to a permanent Lok Adalat constituted under section 22 capital B of established under section 22 capital B of the Legal Services Authorities Act 1987 can deal with the disputes enumerated under section 22 bracketed A, 22 capital A bracketed B, small b, of the act only. Full stop. Which are as under public utility services, transport service, so and so service. A permanent Lok Adalat does not have jurisdiction. Permanent Lok Adalat established under section 22 capital B of the Act does not have any jurisdiction to entertain any application/petition for effecting partition, effecting family partition, even on the basis of compromise. So stop. Learned counsel appearing on behalf of the appellant has not been able to satisfy this court that the application made by the appellant before, even before a continuous Lok Adalat would have been entertained under the provisions of the Legal Services Authorities Act 1987 Full stop. In any case, comma, since the dispute has been raised, since a dispute was raised by the respondents before the learned single judge about the genuineness of the compromise, comma, in our opinion, learned single judge rightly set aside the order passed by the award and the order passed by the learned judge, comma, permanent and continuous Lok Adalat, Kendrapada, comma, giving the parties liberty to approach civil court of competent jurisdiction. First off, we do not find any illegality in the impugned order passed by the learned single judge. This application is, the appeal is accordingly dismissed. Yes.
Item number 8.
Well, in item 8, my lord, I have collected some documents, my lord. I will file to an additional affidavit which is necessary for adjudication of this case, my lord.
What is this about?
Well, here I have challenged the notification dated 22/12/2016, my lord, wherein the petitioners have been treated as ex-cadre. My lord, I have got certain documents.
On behalf of the petitioner is this matter on 4 weeks, so as to enable him to file an additional affidavit.
Item number 9.
Lordship, in this matter, my prior lordship's direction, they have lordship complied, and lordship they have executed agreement on 22/7/2024 lordship. So lordship, in view of the agreement, lordship.
And counsel for the petitioner states that this writ application has become infructuous.
Lordship, they have executed the agreement, lordship. So they have complied, lordship. My prayer has been
since the petitioner's grievance has been raised.
lordship mitigated.
Item number 10.
Please, your lordship. This is regarding renewal of NOC, and you are covered by your lordship's order. Page 12(8), your lordship has disposed of 28 cases that during the election period. So now the order has not yet been uploaded, but the leading case is WPC number 16577 of 2024. It's covered by the same mark.
Which, when was the order passed?
12/8. Monday it was
Monday
before
it was.
lordship.
It will be uploaded.
Yes,
Same mark. As regards to second case, my lord.
Second is to yesterday he has filed the petition given to me. This is regarding not submitted within time. The same similar matters are posted to 27.
Second, first for disposal. Yes.
Item number 11.
May I please, your lordship? Matter relates to an auction conducted by the bank under the provision of the security interest enforcement rules, my lord. The auction notice was published on 26th October 2022. And as per the terms, I participated in the auction and I was held as a H1 bidder in the auction, my lord. Now I deposited the entire amount, and thereafter, my lord, at lapse of more than 1 year, the property could not be given, the physical possession could not be given, and also no registration of the sale certificate was done by the bank. So ultimately, I requested the bank to refund the money, but which they have done, but without any interest, my lord. My petition here, my lord, it's a case where this question has been before the Honorable Apex Court, and the Apex Court in one judgment has been given a 15% interest, in another judgment 12% interest. Your lords will permit, I can defer the judgment. It can be directed by the Honorable Court by
Well, here, my lord, I even two things, my lord, it is creating
If the
problem.
Supreme Court has laid down a law that the courts should award interest in such cases, giving the rates also, rates of interest.
Rate 70, exactly, my lord.
Then
Would-
we will follow. Otherwise,
Then
if
in
no
that
law
case-
has been laid down, some order has been passed.
That
is
case,
not
my lord,
required.
today the matter, one of the matter is before the Honorable Apex Court in the matter of Sushil Kumar Kaushal and Chief Manager and others, my lord, where, my lord, the parity of interest is to be decided. Whether the interest at the rate the borrower paying to the bank has to be paid back to the auction purchaser or not, that has to be decided. It is coincidentally, it is today before the Honorable Apex Court. So
No, but that is not the question. Question is who shall determine that the should be decided by the High Court, or you should go. It's a money claim.
it's in the interest, my lord. In fact, I have no title to go to the suit because there is no agreement to that effect. And even in I cannot approach the DRT also.
So the suit is barred according to you.
My lord, is a surface action, 34 is a bar also. It is also not the assignment of this court.
Then
My lord, registrate thought take it has taken it as a ye matter tender matter.
So where should it go?
Lord, I have no choice. I can also place the matter before lordship.
No, where should the matter go?
At Honorable Justice S.K. Sahu and S.K. Sahu and C.R. Das.
Under what?
Surface.
Surface, eh?
On let the since the case arises out of
Single journey.
Also, then if the banking matter, if it is the banking matter, then Justice Panigrahi.
Surface, yeah. To rise out of that.
Option purchaser.
I am not challenging 13.2 or 13.4.
Your option purchaser.
Auction purchase. Also can be dealt with by the court number 6 also.
Bank
Mhm.
single judge.
Yeah.
For appropriate bench having assignment of bank matters bracketed except surface and DRT.
Yeah.
Yes.
Item number 13.
Partition, my non-defendant has taken time to file the counter affidavit. Today morning, he has sought the copy of the counter affidavit on me, my lord. May I pray let it be taken up next week so that I can go through the counter affidavit.
Current counsel appearing on behalf of the petitioner states that he has received a copy of the counter affidavit today,
morning.
which he needs to consider and file a rejoinder is so required. Also, has requested list this matter on 2 weeks.
Item 14.
14, I'm for the petition of my lord. Last revision, your lordship directed to London State Council to conduct an inquiry on what is the present status of this stone quarry, my lord.
Yes.
But I.
No, 14. It's not been served with the copy. Lordship, particularly
Item
Lordship,
14.
14 is not open.
Even if it is not yours, you have to match it.
CNR, Your Lordship, we have not been served with a copy.
You're asked to file counter affidavit. So CNR is the problem with your office.
Lordship, I'll check up, I'll check.
No defect is shown, so it can't be that. So
Yeah.
Samantha, please.
We'll find, we'll find out, Your Lordship.
Check.
14.
Mr. Mohanty, his name is appearing. And should not have here, Mr. P.P. Mohanty.
Yes, Mr. P.P. Mahath. Where is Mr. P.P. Mahath?
P.P. Mahath must speak.
That apart, we're supposed to serve a copy on the position control board or no?
I have already served copy mail.
On whom? SP Mahanti?
My last occasion also, he was
whom?
there.
There is no representation on behalf of the opposite parties. So from despite
Not 2 p.m.
this court's direction dated 7/8/2024.
District mining officer. should visit
No
the
affidavit has been filed.
Can it be taken out
Can it
2
do-
o'clock so that we can find out from the
Officer
Office,
file.
Find out.
Yes.
Yes, Your Lordship, at 2 p.m. Your
site.
Lordship.
Check the last order.
yes.
Yes.
Mining officer was to visit the site and submit a report.
Yes, Your Lordship, we'll check.
7/8/2024 order.
Yes.
Item number 16.
16. May I please, Lordship? But here, my grievance is very limited, Lordship. I am a successful bidder, Lordship. And as per the terms of the contract, I have to deposit, Lordship, APS within 7 days from the date of the communication of the order, Lordship. Additional performance security, Lordship. If somebody, some contractual reports less to the Lordship, APS, additional performance security, Lordship. That is.
Yeah.
So, Lordship, after being declared successful, they are issuing me letter of acceptance on 27/6/2024, Lordship. And only they have uploaded the same information through website, Lordship. At the relevant time, I was hospitalized because I was suffering from dengue, Lordship. I got the information, Lordship, on 6/7/24. After being released from the hospital, Lordship, I got the information. And immediate, Lordship, on 9, I have deposited entire APS and, Lordship, or the required documents before the opposite parties. But, Lordship, kindly see what they are relying upon. They have given me notice under Annexure 8, Lordship. Sorry, Lordship, under Annexure, Lordship, 6. That is page 59, Lordship.
Yes.
Page 59, Annexure 6.
Yes.
Only what also in first paragraph, Lordship, first paragraph, last sentence only. As such, you are requested to attend this office within 7 days from the issue of this letter for execution of agreement with the following documents. It includes, Lordship, APS and other documents, Lordship. Only one objection, Lordship, comes to my rescue. Lordship, kindly come to page 44. This letter, Lordship, one second, Lordship, I'm saying, Lordship, this letter 59 at the top of the Lordship Annexure 6, it is only sent me by email. Lordship, that is the communication they have done it, Lordship. And Lordship, kindly come to page 44 of the tender condition itself, Lordship, page 44, clause 22, Lordship, page 44.
Yes.
Lordship, 22, notification, award and signing of agreement, Lordship, this terms of contract. The employer oblique engineer in charge shall notify acceptance of work prior to expiry of the validity period by cable, telex, and facemail or email
Not and, or.
Lordship, or email confirmed by registered letter, Lordship. Lordship, had it been a case, Lordship, I could have been communicated through registered, Lordship, letter, then at least, Lordship, I could have been absent from my family members, Lordship. Because I was admitted in hospital, and Lordship, kindly see my bona fide.
On annexure 6, Lordship, kindly come to page annexure 7, Lordship, page 61.
Yes.
Page 61, Lordship, immediately, Lordship, obtaining the Lordship, after awareness of the information uploaded to the website. On 7, Lordship, I have communicated to them. On 6th, I have communicated to them, Lordship. I have released I was not there, I was in the hospital, and immediately I am complying. Then, Lordship, kindly come.
Hospital you have not stated. You have only stated health problem.
Lordship, but the document I have, Lordship, I was in city hospital,
Yes,
I was a dengue in Lordship because he is not given what I have given in the Lordship. That was the fact, Lordship, I was in hospital. Then, Lordship, kindly come to page 9. Again, Lordship, I have given all the documents on 9, and I have given all the documents, FES and Lordship, the required IST, Lordship.
Page 9 or annexure 9?
Annexure, sorry, extremely sorry, Lordship, page 64. This is small consideration, Lordship, because had it been informed, I could have been, Lordship, that no other my intention, Lordship, because I was hospitalized, and because they have not issued me any letter through register post, Lordship, and immediately after.
So what is the action taken?
Action, Lordship, then they are going to terminate, Lordship, by they have issuing the so cause notice.
Where is that?
Lordship, kindly come to annexure 10, Lordship, page 69.
You can respond to this.
Lordship, yes, I have responded, Lordship, annexure 11.
So they will consider it.
They are not considering, Lordship. That's so difficult, Lordship. They are saying, Lordship, they are saying, Lordship, kindly come to annexure 12 series.
All right.
They have, Lordship.
Yes.
The Lordship come to the same Lords, page 64, annexure 9.
No, but
The registered letter, have you sent?
I've seen Lords.
Have you sent by registered letter?
No, that instruction I will take, but he has received it, Lords. He has received it within time. He had the knowledge, and he has admitted that, Lords, on 1st July he was admitted in the hospital, not prior to that. This letter was sent on 26th, Lords. He could have made it, and subsequently, Lords, he, after receiving, he is recovering, Lords, he has said that he has already made those documents ready, so he may be called, not that he has submitted with the authorities, Lords. If you also direct, you
take a
can
decision.
take a decision. We can take a decision within a stipulated time also.
So what time?
Within 10 days, we can take a decision.
All right. I requested on behalf of the opposite parties by Mr. Samanfad and AGA list this matter on 2 weeks for him to inform this court whether any decision has been taken on the petitioners. Where is that?
Lordship, annexure, that is.
Annexure?
Annexure, Lordship, that is annexure 11, Lordship, page 7.
Petitioners reply to the so-called notice. And so-called notice for cancellation of what?
Bid, Lordship, cancel subject.
For cancellation of bill bid.
Lordship, 150.
Item 17.
May I please? My lords, the petitioner in this writ application.
Yes.
My lord, petitioner challenges the allotment of seats for admission to the course of PG dental, my lords. That is annexure 24. It is being contrary to the guidelines prescribed by the government, my lords. My lords, the guidelines is at page 32, my lords.
What is this distribution?
Distribution among direct and in service. I am in service candidate. In the entrance examination, I have stood first, my lords. But because of the allotment discrepancies, I am deprived of the course which I like to
So what are you
pursue.
doing presently?
My lord,
What are you doing presently?
presently I am a doctor.
Where?
This is PG course in Patnagarh.
No, you are a doctor, but admissions have not yet been done.
It is going on.
Going.
I stood fast.
Trustee.
Policy, my lord, space 32.
Guidelines.
My lord. Page 32 is the relevant clause D. My lords, distribution of seats, my lords. The seats will be distributed between in-service and direct candidates of seats on 50-50 basis as per the direction of the apex court. Now, my lords, I bring your lordship's notice to E second paragraph, E second paragraph. Percentage of reservation will be maintained as per as practicable, taking into total seats, college-wise seats, subject-wise seats, that is non-clinical and clinical seats, into consideration, subject to condition that any discrepancies due to odd number will be made good in subsequent years, my lords. It is 50-50. And if anything odd is there, that will be made good in the next year, my lords. Here, my lords, it was started from 2021, my lords, after the judgment of the apex. My lords, now, my lords, kindly turn to page 25, my lords. My lords, 25, page 25. This is
What is the date of this guideline?
Guidelines means
23.
my lord.
But the amendments have also been made in the rules, I think.
My lords, that after 21, the same guidelines is going on, my lords, after the judgment of the apex. My lords, based in 2021, they.
So what do you want?
My lords, there is a particular course which was supposed to be given to the SCB Medical College.
What is the name of the course?
That is oral
Maxillofacial surgery.
Surgery, my lords. It is, if the guidelines is followed, it should be, my lords.
One post.
One post. My lords, what they have done, my lords, one seat. Now this time they have given to High Tech, which is a private medical college. And they have given 2 seats for the direct candidates, my lords. But as per the rules and the guidelines, one seat should have been given to the SCB Medical College, so that I would have availed that course, my lords. That is my grievance, my lord. What happened till today, they have given 39 seats to the direct recruits and 37 to the in-service candidates. It should be 50-50. If it will be 50-50, then one seat should be deducted from direct recruit quota and given to the in-service persons.
They given one to general, one to ST.
My lords, they have given 2. And the matrix, my lords, kindly 1 minute. In 21, they have given 10 seats to direct and 9 seats to in-service. Here there is disturbance. Next year, my lords, in 2022, they have given 10.
These guidelines came into force, those were in 2021 also.
My lord. And next year, my lords, they have given 10 to direct and 9 to in-service candidate.
That is
My lords,
total seats.
Yes. Page 27, my lords, kindly see. Beside 7, 3, 10.
Why are you saying this, that one seat has gone to SCB Medical College?
Not gone.
My lords.
You are saying it's gone to High Tech.
Yes, my lords.
Should have.
High Tech, that is a private college.
This is what I am. Suppose there are altogether 10 seats.
My lord.
In different medical colleges.
My lord.
Oh, in accordance with the guidelines, 5 seats should be filled by in-service candidates.
My,
Wherever the seats are available,
my,
irrespective of fact whether it is
my lord.
SCB Medical College or some other medical college which you are referring to. So we, speaking for myself,
Right.
I am trying to understand why are you saying that this should have gone to SCB?
My lord, so my submission before my lords is that 2 seats should have been allotted to the in-service candidates because till today 39 seats have been allotted to direct recruitment. This is 39 and 37. There is a difference of 2 seats, which should be 50-50, my lord. My lords, each year, 2021, 10 seats were given to them, 9 seats to given to in-service. Next year, 10 to them, this 9, there is discrepancy 2 seats. And this time, though they have
How are
given,
you sure that if 2 seats are, or then you are going to be?
I am fast, I stood fast. So I have the choice.
Lordship, if that were page 24 annex 2. This year, in-service candidates are getting 10 seats and direct quota are getting 9 seats.
Where is that? Oh,
That
this is what
page-
he is saying.
Page 24. So he is the in-service candidate, Lords.
Oh, no, he is saying that past 2 years, 2 seats, 2 more seats
Yes,
than 50%
my lord.
have been filled up by through direct admission. So therefore, this year, that should be compensated.
Lords, this year, that is why this year the 10 to in-service, Lords. 1 more to in-service.
No, he says 2.
No, 2 minutes. Next year that may be compensated, not that Lords, same year should be compensated.
It will be next. My lord, till today, 39 were given to direct. And we are getting 37, my lords. There is a difference of 2 seats. In spite of giving 1 here, there is difference of 2 seats.
And my lords, if you also kindly see, my lords, seats have been given oral this factory, my lords, this is 1 seat to under the direct recruit. He cannot have the option that it should be my lords, SCB or high-tech. He doesn't have that option, my lords. That distribution is made by the DMT.
How?
But what are you following while doing it? What rule are you following while doing it?
That my lords, my friend can say because he is appearing for the DMT, so also the
I am for
council.
the DMT for also PG council, my lord.
All right.
So copy
Find
should be
your
given to
update,
me.
we will see what
Yes.
can be.
Copy should be given to me so that I can give a reply to you.
We should notice.
In fact, 2 and 4
My
will
lord,
give that
some
reply.
interim protection, otherwise it will be over.
When is it?
It is second round is going on.
No entry protection.
My lord,
Silent
subject to result, your lordship, otherwise it will be in fact.
You should notice. So accept notice on behalf of parties you just. Which party you are appearing?
But I am for 1 and 3. My friend, the senior will be my lords, 2 and 4, my lords.
DMT and PG council, convener.
Is this matter on? 1 week. So of considering the urgency of the matter which relates to admission to PG course. PG dental course.
Dental course.
Comma. Let counter affidavit be filed in the meanwhile. Yeah.
Copy.
Copies may be given
Huh,
to me.
notice is issued, so he'll serve copies on you.
Yes.
My lord, I'll serve in.
Course of the day you give.
My
Accepts notice that
One.
copies of the writ application be served upon the council for the served upon the AGA and Mr. Mohanty and council for DMET in course of the day.
And convener. Convener PG.
2 and
2 and
4.
4.
2 and 4.
Huh? So 1 week you can do because
Yes,
otherwise it
I
will
am
become
ready. I
ineffective.
am ready.
Item number 18.
My lords. See a date so that it will be.
28, 21st.
Item 18, this is a pharmacy college wherein the college is
You were
functioning
not
since.
there yesterday, that's why we posted it today.
Yes, my lord.
Today he has given me a copy, my lord. Here the case is that he was been asked to be present with all documents as per his report on 27th of June, but to have some documents to be present by the authority, before the authority. Perhaps he has not attended. The rejection is that the principal details were not available.
So that principle we have given fixed one date,
Yes,
right?
yes, that
Will it cover,
case is covered with the case.
cover that case?
Yes,
Covered by that case.
WPC number 17994 of 2024. A date may be
Nursing.
fixed. My lord,
That case is nursing.
that is nursing. This is also same.
That is pharmacy.
Pharmacol, this is pharmacy. He can be present before the DMAT on a date fixed so that with
Pharmacy now. Or nursing course or pharmacy. Yes.
Item number 20.
This is a matter pertaining to ITI college. Your Lordships, may I take your Lordship's attention to page 14? Your Lordship, this is a association of all the ITI institutes in India. It's a registered body. So there's a common problem which has arisen as far as these ITI institutes are concerned. Your Lordships, the whole thing started with the issuance of Annexure 2, page 15. May I?
Yes.
So, Your Lordship, Annexure 2 is basically an order from the SCST department that you go and make an inspection of various ITI institutes, because this department also finances or gives stipend to certain SCST students who get admitted in this college. And thereafter, Your Lordship, so also the next order, there was, the concerned technical education department issued notices and did some inspection. What happens is thereafter, Your Lordships, after the inspection, there is a particular website where these ITI institutes have to register them to get this stipend. And it was taught for 29 institutes. No reason supplied. So the association made a representation on this behalf that you have just said that there is some discrepancy, but what is that inspection
How
report?
many institutions are
29.
No, 29. They have not been given.
Not been given.
So how many total institutions are there?
I think 450.
400.
50.
So those institutions, though for the other than these institutions, other institutions
They don't have any issue.
support your case.
Yes. But it's a registered body on behalf of that, we are doing it.
They will not.
Because they do not have any issues.
They will have.
No, these 29, now, Your Lordships, may I just give a little brief of the facts? What has really happened is, till that time, there was only blocking as far as that getting that stipend was concerned. So then again, we wrote to them and they said, okay, we'll do a fresh inspection. They did so. It was online on the mobile, they do this inspection. Still then also, they did not provide us any other reports. And now we are totally barred for taking any admission anyway. So now there's a complete bar on us for all students to come. And we've again made a representation, at least provide us a reason. What is exactly the discrepancy? So it's completely a non-reason order. And Your Lordship, several Supreme Court judgments, right from Kranti Associate, which have 14 points laid down, that every administrative decision has to be backed with reasons. If not, it is arbitrary on the face. But the problem is, Your Lordships, according to the central body, the last date of admission is 31st, but according to the state bodies, the last date would be 17th. This is the urgency. And in fact, it's at the last moment that they have passed these orders.
When?
5th of August, Your Lordships.
What is that?
That's the last impugn order, Your Lordships. 5/8/2024, Annexure 12. Thereafter also, he made a representation to them. That what is there in that joint inspection? And very strange.
Annexure
These
12
are-
is to one particular.
Yes, we given just an example. Similar letter, similar wordings to all these 29 institutions.
Oh.
My prayer is if your lordship has been kept on Friday and if instructions can be called for, I think.
So maybe the joint inspection report may be containing reasons.
But the
That is
thing
not
is,
provided to you.
from November you are doing it. Had you given us, we would have fulfilled it. Which in fact the nursing institutes, if your lordships have seen, all the discrepancies, though not a very good example to cite, they used to at least provide some semblance.
Why this is being done?
I'm
Department,
appearing for the,
Directorate of Technical Education and Training.
yes, your lordship, I'm appearing.
What kind of order is this?
Should maybe the joint inspection report was submitted by them, they might be containing the
We'll
reasons as
take up
to.
this matter on Friday.
Friday.
Maybe pardon to mention that contempt matter at item 34.
Friday.
First five cases will take up.
Yes, and they can
Well,
come up with some instructions.
If you can.
Yes, your lordship.
Because
Friday,
Today is
13.
Tuesday, tomorrow. So Friday, it will be taken up on Friday.
Friday, your lordship is a single bench.
Matter will be taken up.
Yes,
All right.
also, yes,
We'll see what can be done.
Well, I may be
If required,
pardoned,
we can sit for this case only.
Okay.
I may be pardoned to mention, my lords. Item 34, the petitioner was directed to be personal, that contempt matter, my lords. She was suffering from fever yesterday and today she is feeling very weak. She also is suffering from fever.
Why was she directed to come?
My lords, that contempt, my lords, that allotment of a house and
Oh, yes.
yes, my lord, she
All right.
is actually very ill. Can her personal
All right, so
today?
you could have filed an application for exemption.
My lord, she has come to the court. She
So
is-
what? It should not have come. All right. 34. So it's personally present. This matter on. 2 weeks will take up.
My lords,
Please inform the other side. Who is
yes,
for
my
you?
lord, we'll inform.
Pardon to mention, my lord,
Obliged.
item 22 is only for withdrawal of the writ petition.
Withdraw.
Sorry,
Any other withdrawal?
item 56.
Yes.
Withdraw.
That neat matter we received the counter today, my lord. I prefer Friday, my lord. We'll file redundant. 56, my lord, first item.
It will come on next week.
Tuesday.
May I pardon to make a mention, my lord? Item 24, today I am filing the.
File.
I will file maybe taken one
All
week after.
matters will come on Tuesday.
Oh, bless my lord.
That will last.
Lords, item 23, I receive a counter today, my lords. Taken up next week any day.
Right. Pardon, my lord, item 37. I'm praying for Tuesday. Tuesday, my lord, coming Tuesday.
Yes.
My lord, item 19, it is a NTA matter. I received some instruction within 2-3 days. There's request for a week. In the meanwhile, they will file the affidavit. If lordship will.
Which matter?
This NTA matter, this examination matter. If lordship will take up, we show the based on the instruction. But the department asked that they ready to file the affidavit within a week.
Matter we call. Just a minute. Just a minute.
Obliged.
Item number 12. Text for two.
So, if your lordship would kindly pardon me.
Yes, sir. Just a minute.
AG 12.
Where is
Sir.
the need matter? We need matter to fix that too. Which item, Mr.
Pardon.
Pardon?
My lord, item 19,
Item 19.
19 and 52 also the NTA matter, along with 56. All are NTA matters. We receive a instruction and they are ready to file a affidavit within a week.
They are asking for to take instruction. They are asking for to take instruction.
So you are appearing in which
OP,
matter?
19 matter
For the petitioner.
for the petition.
So who is there in the other items? All right. Move on. 1B. So as to enable. To take instructions and file affidavit. We taken up as 2. Yes.
1952.
1952 and
1952 and 56, my lord.
56.
52, my lord, were for the petitioner. In that case, the amendment rule of the state government, amending, giving a complete exemption to the OTT qualification which is prescribed under the central act, that is under challenge. Virus, your lordship specifically posted that will be hard. Where the, I think, my lord,
52.
52, my lord.
Not 52.
Sorry, my lord, 52 is not NTA, it is a different matter. 56 our matter.
Yes.
Already adjourned. 21st it is.
21st. Both cases. Yes.
May I please, my lord.
Item
This is a matter-
Yes. Item 12.
The lordship permitted me to continue with other issues involved in the petition so that matter can disposed of in one go and also to reply to the decisions relied upon by the opposite party. Because I have prepared a summary of the cases to facilitate Millers to access the nature of the case involved, Miller. First matter which I have argued yesterday for lordship is 5827 of 2024 Miller. There is commonality of the issue involved in all writ petitions is Miller challenging the notifications under section 168A of the OGS CGS Act. This is common in all, at least in 8 matters in which I am appearing, and I believe in the matters where my friends are also appearing. Apart from 168A notifications, Millers, the issues, other issues are involved, Millers, in 5827 is, Millers, the audit report. Your lordship will see this adjudication, Millers, originates from an audit report.
This audit report is barred by limitation because of 160, because of 168A, it is not barred. This is your case.
No, not for 168A Millers. Because if 168A is allowed, then these are all issues become redundant Millers.
Therefore, this is barred by, this is otherwise barred by limitation.
Otherwise barred by limitation.
But for section 168A, this is your submission.
See, 168A Millers is a distinct issue which your lordship Millers
For that notification issued under 168.
Notification issued on 168A. But so far as the audit report is concerned, my submission is that there is a limitation provision under section 65 as regards to the submission of audit report, which is 6 months. But here on the face of it, this is issued beyond 1 year. So therefore, the audit report submitted by the Annexure 6 is barred by limitation.
So then the cause of action is different.
Cause is different. Exactly.
Why have you added this relief in the present?
The reason being the adjudication order which is challenged, one of the ground is 168A because if that is considered, then the entire things will go.
Therefore, we are of the view that this 168A matter is decided in your favor, then points number B and C.
All others will be redundant. All others will be redundant.
All right. If this issue is decided against you,
correct,
then other things will become redundant.
No, if in my favor, then it will be redundant, Millers. if the main issue, 168 notifications are decided in my favor, all other issues becomes irrelevant, my lords. Because the limit, everything will go.
All right.
But
And if decided against you, then
if it is decided in my favor, against me, then mirrors all these issues have to be, because that is also one of the priority application. Because all other issues, like the one here, a limitation for audit visit, audit report mirrors, that is barred by limitation under the very provision of 65(4) of the CGST OGST Act mirrors.
so therefore, this is irrespective of 168A.
Correct. That's right. This is also one of the prayer made in the writ application.
All right. Yes.
But here, your Lordship may kindly see, even going by index, without going deeper into the matter mirrors on the face of it, notice was initially issued under section 65 on 6/6/22, right, annexure 1 mirrors. Then your Lordship will find another notice was issued, again purported on same provision under 18/3/2023 mirrors. And a reply was submitted in the audit proceeding on 23 March 2023. And a report was submitted on 24/8/2023. Section 65, your Lordship see for a while, that will focus light on the issues, mirrors. Section 65, only 1-2 provisions will do.
Your Lordship, beg your pardon, Your Lordship. Before Your Lordship, starting by my Lord and Senior, so far as the other issues are concerned, Your Lordship, since has admitted the matters on the sole ground of 168A, Your Lordship, we have filed the counter or reply in all the cases, Your Lordship, so far as only 168A is concerned, Your Lordship.
No,
Your Lordship, so far as the.
So is there any order
No.
that this application shall be considered only on the point of 168A? Is there any order?
Your Lordship, at the time of admission of the matters, Your Lordship has stayed by cognizing this notification, Your Lordship.
Different thing.
Your Lordship.
Stay is different. If you confine yourself to an interim order, it's a different matter. But they have filed a writ petition that has to be decided. That has to be decided on merits. It is not that the matter has come on reference before us to be decided on a particular point, and the final matter to be decided by some other bench. So we have to decide, we will finally decide it. So far other aspects are concerned, we will consider what is to be done. Yes.
Section 65 minutes per while.
Yes.
Subsection 1, the commissioner or any officer authorized by him by way of a general or specific order may undertake audit of any registered person for such period at such frequency and in such manner as be prescribed. The officers referred in subsection 1 may conduct audit at the place of business of the registered person or in their office. 3. The registered person shall be informed by way of a notice not less than 15 working days prior to conduct of audit in such manner as we prescribed. Then 4 is important. The audit under subsection 1 shall be completed within a period of 3 months from the date of commencement of the audit, provided that where the commissioner is satisfied that audit in respect of such registered person cannot be completed within 3 months, he may, for the reasons to record it in writing, extend the period by a further period not exceeding 6 months. Explanation: for the purposes of this subsection, the expression commencement of audit shall mean the date on which the records and other documents called for by the tax authorities are made available by the registered person or the actual institution of audit at the place of business, whichever is latter mirrors. Here, therefore, for the purpose of commencement of audit mirrors, the date when books of accounts are produced pursuant to the notice of audit, that will be treated to be the date of commencement audit, and it is to be finalized within a period of 3 months. If the officer concerned is not being able to...
No, but you file this writ petition under the umbrella of 168A.
My lords,
challenging the audit report also.
my lords, my lords.
So that you could have filed a separate application. See, all these applications, in all these applications, you are challenging the notification issued under section 168A. And therefore, all these matters have been taken up accordingly. Now you are questioning the report, audit report, dated 24/8/2023. When did you file this writ petition?
Because writ petition is filed because on 5/3/2024, lords.
5/3/2023. And when you did you file this? You are seeking this. You are challenging the report dated 24/8/2023. How?
This arises from out of pillars, the order where it is dealt in, which is passed.
No. When did you file the writ petition?
That's on 6/3/24, my lords.
6/3/24.
My lords.
So on 6/3/24, you filed the writ petition. You are challenging 168A notification, and then 24/8/2023. This you could have challenged in a separate proceeding.
That's what has happened. What has happened? This audit report pursuant to this so-called issue. I made a reply. Then
that is different altogether.
Then I will take liberty, my lords, because normally
that is a different issue altogether.
normally, my lords, for each and every cause of action, it will lead to multiple writ petitions, my lords.
Then in one writ application, you can seek 100 reliefs. And you may make the court to answer each and every point which you raise on different issue for different reliefs. So this is an entirely different issue.
Different issue.
This audit report is of 24/8/2023. So why didn't you challenge that immediately soon thereafter?
Because it is followed by culminated in adjudication order. And that adjudication order,
You have come to the adjudication order. So you want us to decide that also?
May I just humbly?
no, your lordship may grant me liberty for that. I understand.
Grant
your-
you liberty.
My lord.
That's in all these cases, there are multiple points, so which may not be in many of these cases, like my learned senior's case, there are some other issues involved.
Some other
My
issues
lord,
can be
my
decided.
lord. So my humble prayer before your lordships, my lord, as the Honorable Allahabad High Court has done, they have confined their writ petitions to the notifications regarding extension of time, and they've segregated other issues to be dealt with separately.
Separately before appropriate.
But before the appropriate venue.
Yes.
So if your lordship
forum.
appropriate forum or by way of a separate writ application.
So you have given us enough hint.
My lord, sir.
That is what happened. in
Because
Allahabad High Court.
otherwise, my lord, the entire there'll be a lot of confusion. My
You
lord.
have given us enough hint to follow Allahabad.
My lord,
Those
Allahabad
are
for a limited.
other issues. My lord, sir.
Honorable Allahabad High Court has granted liberty to approach the appellate authority.
No.
Whichever forum.
Yes.
Therefore, we don't know if according to them, there is some other forum, according to under the statute, there is some other.
Well,
forum,
And
then the
226,
appellate
and 226
not
cannot be a
liberty-
bar for us.
But
So far
liberty
as my
cannot
learned
be
friend
granted to
is
file
concerned.
again.
226 cannot be a bar, my lords.
26 is not a bar, but we are not.
Matter is pending, then it is a bar.
The commissioner appeals.
No, to simplify the matter, my lord, my humble suggestion would be
Your suggestion is accepted.
obligation. It's great.
Appropriate forum, your lordship may. Because my lords.
Only leave to challenge.
Leave to challenge, lord. I think that is appropriate.
Lordship today.
Then
With the lordship's
in
permission.
the index, my lords may kindly see, the next matter is also that is arising out of same issue involved, but that is arising out of a show cause, so therefore same order may be. Then my lords may kindly come down for a moment to three matters of swastik scriveners. That is WPC number serial number 3, 4, and 5. 3, 4, and 5. Here there is a peculiar thing that has happened in this case. But out of one audit report covering a particular periods, three separate notices, three separate orders, multiple adjudication orders are passed, which is not permissible, and your lordship have said by way of a judgment here, relying upon one Calcutta judgment, saying that there cannot be multiple adjudication for the same period again and again, my lords. So on that ground only, my lords, I beg your lordships, my lords, pardon me, my lords, in this matter to delve into, because it's a different matter altogether. Out and out not permissible.
We'll allow it.
Even without going by 168A also, the adjudication cannot stand. Covered by our High Court judgment, relying upon Kolkata judgment.
Mr. Misra.
Utkal projects, yes.
7, 8.
Central, that is not your.
It is central.
Central man.
My lord.
You got to file the. Audit reports actually annexed in all the writ petitions, 3 writ petitions are same. Your lordship will find same audit report.
No, there is another division bench decision of this court
Exactly, my lords. Correct,
on
correct.
this point.
Correct, yes. Correct.
There is another division bench decision which says that it all depends on. Do you have that decision?
I have given to your lordship.
No, decision, my decision,
Minus.
presided over by me,
Minus.
authored by me on this point. Do you have?
Saspati, Mr. Submit.
On the very issue, my lords.
Yes. And I have dealt with the Calcutta High Court. judgment.
It's to be. Your lordship.
It should be where the central and state legislatures acted upon the same cause of action.
So the cause of action is the central idea.
Yes, no, but there is a issue, my lord. The 6(2)B says.
That is different because once central
that is
agency
a
belongs to
different aspect,
application,
You
state
remember
cannot
what
again
that
on the
is,
same
that
subject
is
cannot
Your
take
lordship,
Same subject.
that-
The same subject is
Same
the.
subject, your lordship.
Your lordship.
Same subject.
Correct,
Your
correct.
lordship distinguishes that, not the same assessment here.
Mr. Beura was for
Yes,
the petitioner.
that your lordship
And we
disposed of the
both,
same.
6 to be different mirrors. Because here what is happening, out of same audit report for the same period, instead of taking up in one adjudication order, there are 3 notices, 3 adjudication orders, multiple assessment done based on the same report mirrors, which is not permissible, you lordship have said. In the Utkal project's case, relying upon mirrors, Kolkata judgment mirrors.
And 168 is not under challenge there.
Also mirrors,
Notification.
also mirrors.
Oh.
It is necessary, I think, to get that same country.
Perhaps, may I pray one thing?
Your lordship, that is Satyam casting. That is the case in case of Satyam casting. That is 2530 of 2024 WPC number.
So it's decided by this bench.
Your lordship, on dated 5th April 2024.
Huh? It just is.
That is your lordship sitting with Honorable Justice S.K. Sahu.
That's what I'm praying. If your lordship grants me liberty to take up the issue in a separately, my lords. So that subject to outcome of my lord's judgment that will fall for 168A. If that comes in my favor, then certainly in all other redundant. If also that fails also, separately I can pursue the matter that leave can be granted. I will approach in separate writ petition, leave may be granted so that my lords. These 3 matters belongs. Sabu. Serial number 7 has become infectious, my lords.
10584.
10584. This has become infectious.
Why?
Because I have challenged initially against the show cause notice and in the meantime order has been issued. So therefore order is challenged now that has been.
That is a serial number 5, your lordship, the order which is challenged.
6.
6 is there, but 7 has become infectious.
No, you must have challenged in 6.
6. Liberty number 2, 3, 4 and 5.
As far as item number 6, I am appearing, Manoj.
So observing that can be disposed of.
Manoj, may I just
Just a minute, Mr. Sorry.
One more, Milosh. So far as yesterday I was submitting your lordship challenging section 16(4) and 16(2)(c), which are substantive issues, Milosh. Again, Milosh, there will be too much hardship, Milosh, possibly a very difficult task. I am not pressing challenging section 16.4 and section 16.2.
See.
16.2C of the Act. Because the buyers of these two substantive provisions are on a challenge, I am not pressing for it. That is in the case of the serial number. I have mentioned in the list also, specifically not pressed, serial number 3, serial number 4, and serial number 8 minutes.
You're not 16 to 64.
No, we are not pressing.
But that is not in your prayer.
Yes, it is in my prayer. Those central actors,
All right, yes.
Therefore, in nutshell, what I am submitting your lordship is, all other issues belong to your lordship for regard liberty to approach separately.
Appropriate forum.
Appropriate forum.
Forum, authority, court, what?
Court, yes. And now,
As may be advised.
as may be advised. Next is, with my lord's kind permission, only I will be replying to the two judgments relied upon by my friend. Yesterday, I have taken your lordship's liberty minutes too. Plus, first, the judgment of Graziano, Allahabad High Court judgment, which is heavily relied upon by the opposite party. First of all, you also can see page 2, paragraph 2. Because that is a case why I am pointing out to paragraph 2 of the judgment minutes. Challenge has arisen to notification number 9/23 dated 31/3/23. This is the last notification extending the date out of outer limit for passing adjudication under 79 dated 79 with 7010. Whereas the 5/7/22 earlier notification, this was not on challenge, which was before your lordship. Here only one notification is on the challenge. And the Honorable Allahabad High Court confined all the petitions, restricting the challenge to this notification is 1718 also. In paragraph 4, my lords will kindly see. Paragraph 4, challenges are also involved in the other petitions for financial year 1718 on other grounds, including grounds that adjudication order extending to focus principal natural justice having violated rectification so and so. Yet other petitions are laid down challenge to similar notification for 1819. In those cases, legal grounds of challenge have been described with different. Another petition filed challenging validity of 168A. Here they are not there. 168A is now it's there. Other issues are there here. In view of varied challenge raised in some individual petitions at suggestion bar, we have confined the hearing at present to writ petition involving challenge to notification dated 31/3/2023 issued by central government and as well as parallel notification of state government on 24/4/23 described and so on so for the year 2017-18. Petition raising challenge to validity of 168A has been segregated. Those may be heard later. Also, petition involving challenges at the time of to the time extension notification relevant to the 1819 will be heard separately. So that means Honorable Allahabad High Court confined the whole of the judgment to 2017-18 and notification dated 31/3/2023, which is also one of the notification on a challenge in this petition. So now that is the scope of the matter dealt in by the Honorable Allahabad High Court. Then you also may kindly turn to state paragraph 83 minutes. Para 83. Before we proceed to deal with the submission advance, it will be useful to take note of relevant provisions of the statutory law, notification, statutory action relevant to dispute brought before us as they existed at a relevant time. Then just I am pointing out, they have referred to 44(1), they have referred to all notifications, then Supreme Court order in the that reference matter, cognizance for extension limitation. They have also referred to, your lordship will find, the 47th and 49th council meeting, all these are there. So I need not go through all those because that has been placed to your lordship yesterday, my lords. Then my lords may kindly turn to my lords, paragraph 100. paragraph 100. Tested on the above principles as a fact, the
Please read.
the recommendation of the council to issue the impugned notification to extend the time limit exists. Also, the occurrence of the force majeure circumstances that the epidemic 19, COVID-19 is undisputed. Therefore, it is required to be considered is whether that power is exercised in respect of in respect of actions which could not be completed or complied, and two, duty force majeure. These are the two things which the court wanted to test, whether these are there or not. And one thing, COVID-19, our provision says, section 168, epidemic. This is pandemic. Etymologically, whatever I have checked, these two are different. So it is again to be seen whether pandemic comes under epidemic or vice versa. That is again another
What
question.
is there?
That's 168. You have seen the other day. It speaks of epidemic, war situation, epidemic, earthquake, fire, all that.
So what is more serious, epidemic or pandemic?
I believe pandemic as more, yes,
Then
absolutely.
is it not included in endemic?
No. Sorry?
If it is more serious, is it not included in epidemic?
Epidemic, etymologically, we cannot.
Etymologically.
There is no
Pandemic
just
is
for the sake of apprisal, it is not so far as language of law is concerned, it is epidemic. But what has happened is pandemic. But just etymologically different. I do not say advance an argument that it cannot be or could not have been. Just I am reading.
All right.
Minus. Next is going by paragraph 102. The submission advanced by senior counsel and other counsel for the petition that since adjudication notices were not issued, the period of limitation never started running, and that there was no requirement to conduct scrutiny or audit before issuance of those, and therefore the revenue authority were not disabled from conducting that exercise requires serious consideration. So what is happening, Lord? Your Lordship have seen the expression could not be completed or complied with. So completed question will arise only when there has been initiation. If there is no initiation, then it cannot be contemplated of completion, Milords. So here, even in my case, Milords, yesterday I have showed to your Lordship the notice. Your Lordship will find the the notice your Lordship will find SCN, so-called notice, is issued on 26/9/2023, Milords. And the order is passed on 30/12/2023 for 17/18. So therefore, this all goes to imply that Milords, on 30/9/2023, which is at the end of the extension granted by 5/7/22 was, you also have seen 31/12/23. Notice is to proceed by 3 months before. So when so much time, more than 4 years, almost 4.5 years, time was available to them, what was the need of issuing, even if your Lordship goes by the extension granted under 44, your Lordship must have in mind the date 7/20, Milords, the last date extension under 44. Then adding 3 years, it was 7/23, Milords. So court has also, Honorable Allahabad High Court has also mentioned that. So going by that extension, February 2023, for the purpose of completing adjudication, Milords, on the 7/9/10, the notice would have been issued by November 22, Milords. Even going by that also. So if somebody abdicates his own power, doesn't function, barring 2 years, Honorable Supreme Court said pandemic, your Lordship for all the documents, which ended in February 2022, only barely 2 years. 2 years was also not that it's zero functioning, with restrictions functioning, like our High Court, it was also functioning well. So therefore, and not only that, the circular which I have pointed to Lordship, you have Lordship seen that Honorable Supreme Court's that interim order, giving go by to limitation for 2 years periods, that doesn't apply to GST law. So therefore, my humble submission precisely is, even under these circumstances, the authorities cannot keep quiet. You cannot keep quiet
do not proceed anything when there is no such restriction on your part to issue notice, to go for adjudication, to go for scrutiny, to go for investigation, all that. So by keeping quiet, you cannot at the last moment say that again you grant us more time. Then there's paragraph 104 minutes, 104 minutes. Seen in the light, discretion existed with the principal legislature to prescribe such a limitation as it may have considered proper. In fact, it is a submission advanced by some of the learned counsel for the petitioner that if the prescription limitation is provided by the impugn notification had been made by the principal legislature, there may not have arisen any valid challenge thereto. So the submission, it in fact followed from 103 also, that it's a primary legislative function of the legislature by parliament bills and the delegate bills in exercise of delegated power conferred by the legislative provision bills that cannot stand equated with parliamentary power. Honorable Court says that the notification which is issued, it's not an administrative function, it's a legislative function. But legislative function, I will bring your lordship the judgment here also, that is also quoted in this judgment, saying that even if it can be said to be a delegated legislative function, it cannot be equated with that of primary legislative function. Because there are very many restrictions that has to be abided by in exercise of power under delegated power of legislation. So therefore, it's an admixture of administrative legislature because they have to keep in very many factors. They can't, unlike parliament, have plenary power. They have limited power. And that limited power is always will yield to plenary power. They can't overreach. So therefore, then my lords may kindly turn to my lords, paragraph 110 for a moment. Once we have held that issuance of time extension application was a legislative function, and there existed material and due deliberation consideration over to that material before the legislative function was performed, the first condition of existence of circumstances for exercise of the said power, described as conditional legislation, stood fulfilled. Therefore, issue of the decision in case of Mohit Minerals Private Limited is also of no avail. By way of principle, it may not be doubted that the recommendations of the council remained persuasive. The central government and the state government were not duty bound to conform thereto. However, in absence of any facts shown to exist, the central government and the state government had exercised their conditional legislative function in accordance with law. No palpable illegality or arbitrariness has been shown to exist as may warrant any deeper examination by the court. This is how the honorable court has dealt in. Now, my humble submission is that because whether there are actual materials, tangible materials, which can be accessible to your lordship in exchange of power of judicial review to find out whether the materials are in fact cogent and germane to reach the conclusion which they have arrived at for the purpose of issue of notification invoking 168A. Because your lordship, even if wants to know, that cannot be because palpably those are invisible. Nothing is there, neither in 47th council meeting resolution, nor in 49th council resolution. Nothing is there, lordship. If your lordship wants to know also, your lordship cannot, we also cannot, public also cannot. So therefore, honorable court, I don't think it is best and proper reasoning to say that there are materials. So therefore, once there are material recommendations made, you can't question that. And court will also go slow to interfere. So I think these are apparently absent, so that it requires review, appropriate review. Then your lordship may kindly turn to me, lords, paragraph 112.
Yes.
Sorry. Then directly material to our discussion before the council, it had been specifically represented to provide for suitable extensions of time, keeping in mind the fact that the scrutiny and audit work with respect to annual returns, my lords may kindly keep in mind this, annual return for the financial year 2017-18, 18-19, 19-20 could not be done for reason of reduced working staff, staggering timing, and exemption granted to various category of employees to attend office establishment during this period of pandemic-19. It was specifically included through the agenda item material that no action for scrutiny and audit could be undertaken during the initial period of the GST implementation. That recital may not be cited as a self-disabling act of revenue authorities. It is undisputed petition that the last date of filing annual return for 17-18 was extended up to 7-20. Consequently, no scrutiny of audit, this year also may kindly mark emphatically. Consequently, no scrutiny of or audit for financial 17-18 may have been effectively undertaken before that day. That function may have arisen only within a reasonable time thereafter. This is patently contrary to the provisions, because the annual return due date filing mirrors. That has nothing to do with scrutiny and investigation audit mirrors. These are all independent actions contemplated under the statute mirrors. Section 65 mirrors provides for audit. Section 67 provides for investigation mirrors. And there is complete mechanism provided for audit and scrutiny mirrors. Section 61 of the OGS CGS style also will find complete mechanism. Going by provision and act and rules, my lords will find that the authority shall, for the purpose of scrutiny, that the language which is made. It is not that, unlike VAT law, the lordship will find from VAT law, each and every return filed by a taxpayer shall be subject to scrutiny laws. That is there in the law itself. But such a law is not present here. The language may means the proper officer, if so likes, may scrutinize a return, may not scrutinize. Audit also similar language used, may audit, may not audit. If it requires, audit is required, they may also. So, going by the provisions, your lordship will find these are discretionary provisions. If necessary, they may go for scrutiny and audit matters. So therefore, the last due date for filing annual return has no link with this. And the Honorable Court has referred to even mentioning the provisions of 61, 70 and 67 saying, 61 says, in court for scrutiny, if after notice I fail to comply, then that will be referred to adjudication for 73. That by itself does not mean that without annual return that cannot be done. Without annual return that can very much be done. Similarly, same provision is also there in investigation, 65 audit also. If audit cannot be complied with, then the audit officer may send for adjudication on 73. So by recording those provisions and stating that the impugned provisions of 61, 65 also culminates in 73, that does not per se indicate that it is linked to annual return. It has nothing to do with it. So therefore, the reasoning given in 112 doesn't survive minutes. It is patently under law.
Yes.
Then next 113. As to construction of reasonable time, in the context of the legislative policy providing for a 3-year time to frame an adjudication from the last day of filing annual return, and further keeping in mind the legislative policy providing for issuance of so-called notice up to 2 years and 9 months from the last date of filing of annual return, that reasonable period of time extended up to November 22. I was just little while before telling our lordship bearers, even going by 7 to 20 and 7 to 23, 3 months to 75-2 says, 73-2 says that the notice which is to be issued for adjudication must at least be 3 months prior to the end of date.
Yeah.
So therefore, November 22, that by itself will not matter, because your lordship have seen here in my case also, at the fag end of the year after 4 or 5 years they are giving notice. So that doesn't help. You could have done earlier also. So the reasoning doesn't stand matters. And then 114 paragraph, you lordship kindly see, they have, Honorable Court has referred to Supreme Court's order. While the order of the Supreme Court in the cognizance for extension limitation may not per se apply to an adjudication proceeding, and it is not the case of the respondent that they claim direct benefit of that relaxation of limitation granted for the period 15 to 22, 28 to 22. At the same time, we must remember that judicial notice was taken of the disabling events triggered by the spread of pandemic COVID-19 by the highest court of the land. That judicial recognition of the fact that was commonly known to all itself is irrefutable evidence of both the extent of disablement and the length of time for which the disablement continued to exist unabated. In face of recognition and established truth, no use or purpose will serve in offering any deliberation. Therefore, we conclude the revenue authority visited with circumstances that was not of their making. It was not a mere difficulty of the usual kind. It was not a wholly temporary transient impairment caused to their functioning. Beginning 15 to 20, it had disabled the working of revenue authorities over a long period, occasionally force majeure. This is wrong. This is wrong. Why? Because yesterday I have brought to your lordship's notice a circular issued by the Government of India, my lords, dated 27/2021, which I have annexed to my regional affidavit. My lords have said that the Government of India, after taking legal opinion from experts, my lords, have notified for the concern of field formation as well as the general public that the limitation period which is there by the Honorable Supreme Court in the interim order that irrespective of limitation under the Special or General Act, these provisions shall stand excluded. These limitation doesn't apply to GST law, my lords. Government of India on their own thing they have said so. So therefore, it doesn't preclude the officers from proceeding with their normal duties of return verification, checking, audit, all that. So that stand they cannot take, my lords. That is contrary to their own circular, my lords. Next, my lords, I will bring to your lordship notice, my lords, 117. Paragraph 117, my lord. Also, we are unable to accept the submission advanced by Law and Counsel by the petitioner that the process of framing adjudication order is independent of scrutiny and audit of annual returns. To offer that construct to the language of Section 71 would be oversimplistic. It is true that Central Act and State Act specifically do not contemplate. Court admits here, it is true that Central Act and State Act specifically do not contemplate existence of limitation for prior scrutiny and audit. At the same time, Section 61 of Central Act and the State Act provides that a proper officer may scrutinize the return, verify its correctness, and inform the registered person of discrepancy notice. Is the explanation that is found acceptable, no further action is contemplated. Failure to comply with those conditions may invite Section 65. I have already argued on this, my lords. I did not, my lords. Now 119, my lords, may kindly see for while. To us, the above discussion is enough to persuade us to the conclusion that scrutiny and audit of annual return is inherently linked and is not independent of adjudication proceeding under Section 73 of the Central and State Act. Though the proper officer may remain authorized to act under 73 of the Central Act State Act, independent of an audit and scrutiny, they admit here, my lords, independent of audit and scrutiny, they can go for 73. At the same time, that outcome would be dictated by facts of an individual case, but not by your principle of law. In the entire scheme of Central and State Act, by your procedure, steps contemplated under some 61, 65 would remain a normal occurrence. By very nature and by virtue of specific provisions Central Act and the State Act, these would have to precede action under 70 of those enactments, which is not a factor contrary to law. This is not to require to precede. This will have independent action of its own. So therefore, it cannot be said that 73 is intricately or statutory requirement of linking to the outcome of 61 and 65. Nothing. It's not requirement of law. Then straightway I am taking my lord's attention to paragraph 124. 124. Only two more paragraphs are there. 124, my lord.
Yes.
But so what then requires consideration is, if the words due to force majeure would include a period of time during which no lockdown may have been declared, or during human or economic activities may not have been specifically disrupted by issuance of appropriate orders under the Disaster Management Act 2005, first, in the context of a legislative function, the Reed Court sitting in judicial view may not look to the test of subjective satisfaction of the legislative body or its delegate to see if the law made had the exact measurable fact justification for its enactment. The legislative wisdom must remain insulated from that judicial query. Under the constitutional scheme of diversion of division of powers, courts may never be enthusiastic and remain disinclined to test the subjective satisfaction of legislature in enacting laws. In fact, the courts are neither equipped nor they are expected to undertake that exercise. Because this doesn't work so far delegated legislation is concerned. It is not unlike primary legislation that court would go slow. Even at times also when serious challenges are made, your lordship have also power to look into. But here this is a matter where we have challenged the delegated power of legislation by the government bills. So therefore, this then next bills, my lords will kindly see 128 bills.
128.
28 bills. Submission that the resolution of the 49th meeting of the council offered only a partial modification of the first time extension also cuts no ice. The improved notifications remain referable to exercise of legislative power under section 168A of the Central Act and the State Act. It was exercised in the manner prescribed. The fact that the council choose to make a partial modification remains within the insulated realm of legislative wisdom. But these words, my lords, may kindly keep in mind what is mentioned here. Your lordship may kindly again, my lords, roll back to yesterday's argument and the resolution which I have shown to lordship, my lords. Yes. 47th council meeting. 47th council meeting is based on the report of the law committee, my lords. And law committee, the buzzword that constraint time, staggering time, Then limited attendance of the staffs, exemption granted to some employees. So these are there, these are the buzzwords, these have been repeated, Milords. Milords, on the basis of that, Milords, law committee report on those reasonings, Milords, let me not reiterate that council, without any further investigation, without any tangible material, nothing is visible, has accepted in toto and made recommendation to the law ministry for vetting. It doesn't say that it is sent for your consideration. It says for vetting.
See, we have seen that, and so much so that at least one of the members, the opinion which was expressed by him, that has been recorded.
Correct, Milords. From Bihar, Milords. Yes.
Whatever.
No, Milords. Yes, I have
It is
seen.
not that that was an empty formality of accepting the recommendations made by the law committee.
Correct.
There was some discussion.
Some discussion.
Might have the court is not required to go into the aspects which were discussed.
Correct.
All right.
My lord. But now the question is, you're also right.
Your submission was that there was absolutely no application of mine. They just accepted whatever was suggested by the law committee. Not that there was discussion, agreement.
My submission would be what your lordship says. Apart from that, let us assume they have applied their mind in 47th meeting. Was there any improvement of fact? Was there any additional material which was considered in the 49th council meeting so as to persuade them to go for another 3 months extension? Answer is no, Milords. Same, the wording is repeated here. Because had there been...
You are more agreed by 3 months.
Exactly, Milords. I don't have any Milords. I am in agreement with that. I don't have any grievance. If your lordship sustain that also 5/7/22, possibly I will not have a grievance. I will not have a grievance. But so far the second 49th and the outcome culminating in the second notification 31/23 Milords, 31/3/23, we have serious grievance, Milords. That is my humble submission. Rightly, you also have followed me. First, I don't have. I may not have, Milords. But second, certainly I have. No material. Your lordship will kindly reconcile 47th meeting material, 49th meeting material. Nothing. No additional nothing. Now my lords will kindly turn to Milords. Paragraph Milords 133. 133.
Yeah.
And the submission as to disability of the performing duty, performing party. Disability of the performing party means the office of the department.
Yes.
While attractive in first place, the same does not require any deeper consideration in view of the discussion made above. In the context of a legislative action, as noted above, the level of disability suffered is not justiciable. Unless shown to be manifestly unreasoned or possibly arbitrary or plainly opaque, judicial power may remain to exercise to examine such issues any further. Suffice to note that the pleadings made in the counter affidavit are not to be seen to test the validity of the law. Even if nothing is there in the counter affidavit, but that may not be enough, you also can also proceed on its own. That is what the rule court has said. Burden to establish the invalidity existing petitioners. As noted above, we find that burden has remained from being discharged. The fact that the central government lifted the measures enforced by it under the Disaster Management Act in 2002. Here also, court admits that all the those are impediments, those are the restrictions that are lifted under Disaster Management Act in 2002, 2022. Sorry, leads us to know here they do not militate and they may not ever militate against the judicial notice taken to the effect of the spread of pandemic 19 remained constant during 15th March 22, 25th March 2022. This round may not impact in any manner because during this time also GST law operation remains unimpacted as per the government's own circular, and also it was said that all scrutiny return, everything will continue as it is, as usual. Then lastly, to go 136 minutes. This is very, very important. This goes to the very root of the issue, minutes. Paragraph 136 for a while. That is the case, Milords, of the Honorable Apex Court Judgment P. Krishnamurthy, Milords. I am only taking my Lord's attention to paragraph 17 of that judgment. Your Lordship may skip 15, 16 and turn to paragraph 17. In Indian Express newspapers, Bombay Private Limited versus Union of India, this court referred to several grounds on which a subordinate legislation can be challenged as follows. 1. A piece of subordinate legislation does not carry the same degree of immunity which is enjoyed by a statute passed by a competent legislature, subordinate legislation may be questioned, like the present notification questioned on any of the grounds on which plenary legislation is questioned. In addition, it may also be questioned on the ground that it does not conform to the statute under which it is made. It may further be questioned on the ground that it is contrary to some other statute. That is because subordinate legislation must yield to plenary legislation. It may also be questioned on the ground that it is unreasonable not in the sense of being reasonable, but in the sense that it is manifestly arbitrary. Here also we have pointed out for Lordship some primary facts for the Lordship's constitutional and judicial review of this. So for the background of the issuance of notification order, once it is concerned. Now, paragraph 19, that is the case of Sri Sitaram Sugar Co. Limited versus Union of India, para 47. Power delegated by statute is limited by its terms and subordinate to its objects. The delegate must act in good faith, reasonably intraverse the power granted, and on relevant consideration of material facts. They must consider material facts. All his decisions, whether characterized as legislature or administrative or quasi-judicial, must be in harmony with the Constitution and other laws of the land. They must be reasonably related to the purposes of the enabling legislation. If they are manifestly unjust or oppressive or outrageous or directed to an unauthorized end or do not tend to some degree to the accomplishment of the objects of the delegation, the court might well say Parliament never intended to give authority to make such rules. They are unreasonable and they are ultra-vires. In St. John Teachers Training Institute versus so this court explained the scope and purpose of delegated legislation in the words like, a regulation is a rule or order prescribed by a superior for the management of some business and implies a rule for general course of action. Rules and regulations are all comprised in delegated legislations. The power to make subordinate legislation is derived from the Enabling Act, and it is fundamental that the delegate on whom such a power is conferred has to act within the limits of authority conferred by the Act. Rules cannot be made to supplant the provisions of the Enabling Act, but to supplement it what is permitted. The delegation of ancillary or subordinate legislation function, or what is functionally called a power to fill up details. The legislature may, after laying down the legislative policy, confer discretion on an administrative agency as to the details, as to the execution of the policy, and leave it to the agency to work out the details within the framework of policy. The need for delegated legislation is that they are framed with care and minuteness when the statutory authority making the rule after coming into force of the Act is in a better position to adapt the Act in special circumstances. Delegated legislation permits utilization of experience and consultation with the interest affected by the practical operations. What it says, delegated legislation permits utilization of experience and consultation with the interested affected parties like the weak people, like the taxpayers' billers, delegated taxpayers, or by whatever mechanism they can develop for consultation process. So they must be, the person impacted must be consulted. That is what the Honorable Court meant. Only one paragraph last, that is the ending conclusion paragraph 138. Seen in that light, the distance cited by Royal Council petition found to be distinguished. The writ petition challenging the notification must fail. Hearing all cases where adjudication proceedings are pending may recommence and be concluded after excluding the duration of stay of the extended limited petition to adjudication order. Whatever adjudication orders in the past, recovery is stayed by the court. Petition shall within 45 days refer appropriate. So this is how the matter is dealt with by the Honorable Allahabad High Court. And the reasoning granted, your Lordship have seen, which is required to be verified by Lordship, whether it addresses my Lord's conscience. My Lord's
but we have not been addressed on one point that is very good.
My Lords.
And that is the principles of committee. One, High Court has taken a view with reference to a notification issued by the central government on its validity. So whether another High Court should respect that or not.
I think in all that may not bind you.
This is a very, very important aspect which was required to be addressed and has not been addressed.
many a
I
cases,
don't know whether there are decisions on this point or not. And senior counsel will come.
Yeah, it says exactly what your lordship says, your lordship. Those judgments say so. My Lord Justice Chagla in 1955
Right.
says, I disagree with this, but since a central act, we'll follow it.
Right. So this is this is how the federalism works. Otherwise, the different courts taking view on one provision of law, that will create a very, and therefore that we do apply the principle. We'll hear you, Mr. Sridhar, after this.
No, I'm here.
May I just take your lordship's 5 minutes more?
Oh, yes, 5 minutes.
So at the outset, I'm so far as my matters are concerned, there are just two matters above the penultimate matter. That is WPC 14909, 15642 of 2024, and 15658 of 2024.
So Mr. Sahu has made our work this task easier because he has given this. If you can also do that.
I'll do it. I'll do it. Because I'm just concerned with two matters. I'll only engage your lordships with one matter.
2 or
So
3, Mr. Kar.
Three. But so far as the WPC 15642 of 2024 is concerned, this, my lord, deals with a refund matter, my lords. A refund was sanctioned. Then steps were taken, my lord, to get back the excess refund, my lord, can. At the outset, my lord, I have also raised the question of whether proceeding under 73 of the GST Act, my lord, would be permissible to take up the excess refund or collect the refund which has already been given, my lords. That your lordship may kindly grant me leave, my lords, to challenge it in other proceedings. I'll only confine my argument, my lords, to the effect of the notifications so far as my refund is concerned, my lords, and whether there is an extension of time so far as claiming of excess refund is concerned, my lords. My pleadings so far as 15642 of 2024, it begins at page 26 of the brief, my lords. I'd quickly take your lordships, my lords, to a table at page 27, if your lordships have the brief, where, my lord, I have said that the normal time which was available under the Act dehodes the notifications, my lord. If your lordship would kindly take up page 28 of the brief, my lords.
Yes.
There were 4 refund sanction orders, my lords. The lordship has 15642 of 2024 minutes.
Yes. Please.
My lords. At page 28, my lords, I have given the 4 refund orders date, my lords. Unfortunately, my lord, the heading of that column, my lord, begins at page 27, my lords.
Yes.
So one is dated 14th of February 2019. Second one also 14th of February 2019. The third one is 3rd of April. The fourth one is also 3rd of April. So the normal time, my lord, of 3 years would have expired on 14th of February 2022 in 2 cases and 3rd of April 2022 in other case, my lords. And the normal time for issuance of a show cause, my lords, that is 3 months prior to the date of the order, my lord, would be 14th of November 21 in 2 cases and 3rd of January in 2022, my lords. I'll not take your lordship to the averments, just to the table, my lords. Then if your lordship would take up, my lords, the so motor cognizance order, my lords. I've just calculated that at page 32, my lords. I made out a chart. So the total time available, my lord, for them was, my lords, 730 days, my lords.
Yes.
But before that, I'm sorry, my lords. If your lordship would take up the so motor order, the table begins at page 30, 30 minutes.
Yes.
So the total time available as per the so motor order is 716 days, my lords. I've calculated that exclusion period, my lord. So if this 716 days is added, my lord, to the last date, my lord, that, my lord, if your lordship would come, will take us, my lord, for the 14th of February 2019 order would take us to 31st of January 24 in 2 cases and 19th of March 2024 in the other 2 cases, my lords. At page 30, if your lordship would see. And accordingly, my lords, the show cause notices, which is contemplated under 73(2), would be 31st of October 2023 in 2 cases and 19th of December in 2 cases. That is, if your lordship would take the so motor cognizance order, my lords. But if your lordship would take into consideration, my lords, the notification number 13 of 2022, my lords. Before that, my lord, I'll take your lordship to notification number 13 of 2022, which is page 180 minutes of the brief minutes. And this page 180 minutes.
Yes.
This particular notification, my lord, was a resultant effect of the 47th GST Council meeting minutes. There, your lordship.
18, you are referring to page 118.
180, my lord, 180.
180. Yes. Yes.
Then I'll just take your lordship to Roman 1. What was extended, my lords? But
Yes.
in exercise of powers conferred under section 168 of the Central Goods and Services Act, so and so, herein referred to section 20 of the IGST Act, 21 of the UGST Act, and in partial modification of the notifications of the Government of India in the Ministry of Finance Department of Revenue number 35 of 2020, dated 3rd of April 2020, published in the Gazette number so and so, dated so and so, GSR so and so, and for notification 14 of 2021, dated 1st of May 2021, published in Gazette number so and so, so and so, the government, on the recommendation of the council, hereby Roman 1 extends the time limit specified in subsection 10 of section 73 for issuance of order under subsection 9 of section 73 of the said act for recovery of tax not paid or short paid, or of input tax credit wrongly availed or utilized in respect of tax period for the financial year 17-18 up to 30th day of September 2023. Now, I'm concerned with small Roman 2, my lords. Extend the period from 1st day of March 2020 to 28th day of February 2022 for computation of period of limitation under section 70, subsection 10 of section 73 of the said act for issuance of order under subsection 9 of section 73 of the act for recovery of erroneous refund, my lords. Lordship Court. So if your lordships would add up the period from 1st day of March 2020 to 28th day of February 2022, my lord, your lordship would have 730 days, my lords. I've calculated that, my lords. So this particular table, my lord, at page 32, my lords, says at page 33, if your lordship would see, that this 730 days, if it is added as per notification 13, my lord, would take us, my lord, for 17th of February to 14th of February 2024, 14th of February 2024, and then other 2 to 2nd of April 24 and 2nd of April 24, my lords. So, my lord, beyond April of 2024, my lord, this notification does not work. So in this particular case, my lord, the adjudication order, my lord, is dated 26th of April 2024, which is far beyond this period given, my lords. And why I'm saying so, my lord, is except, my lord, for this notification number 13 of 2022, my lord, in the further notifications which I've annexed, my lord, at annexure 11, my lords, that is notification number 9 of 2023 at page 181, they do not speak of erroneous recovery of refund, my lords. So this is the only notification which extends the time so far as claim of erroneous refund is concerned, my lords. Neither notification number 9 of 2023 at page 181, nor the last notification of 56 of 2023, annexure 12 at page 182, they contemplate, my lord, about recovery of erroneous refund. And to take your lordship to the provisions, my lord, if your lordship would kindly permit me, my lords. So far 73, 9 and 10 is concerned, my lords, if your lordship would permit me. Your Lordship, you just come to 72 first. May I just place it?
Yes.
The section 2, my lord, the proper officer that shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of order. Then your Lordship may come to subsection 9, my lords. The proper officer shall, after considering the representations, if any, made by persons chargeable with tax, determine the amount of tax, interest, and penalty equivalent to 10% of tax or 10,000 rupees, whichever is higher, due to such person, and issue an order. So your Lordship would appreciate that this concerns about chargeability of tax, determination of amount of tax, interest, penalty, and the quantum is given, Lords. So far as subsection 10 is concerned, the proper officer shall issue the order under subsection 9 within 3 years from the due date for furnishing of annual return for the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relates to, or, my lord, I'm with this segment, my lord, or within 3 years from the date of erroneous refund. So erroneous refund is separately dealt so far as subsection 10 is concerned. And all these wordings, my lord, your Lordship would, if your Lordship would kindly go back to that notification, your Lordship would see at small Roman 1, my lord, at the cost of repetition, if your Lordship would just allow me to place that language, my lord, extend the time limit specified under subsection 10 of section 73 for issuance of order under subsection 9 of section 73 of the order for recovery of tax not paid or short paid, or for input tax credit wrongly availed or utilized in respect of a tax period, so and so, so and so. So this, my lord, is a part of 7310, nothing to do with the recovery of excess of refund already granted. So the small Roman 2, my lord, is the only provision which deals with recovery of erroneous refund, my lords, and it excludes the period from the 1st day of March 2020 to 28th day of March 2022. 28th day of February 2022, my lords. So am I clear, my lords? And this particular aspect, my lord, if your Lordship would compare this notification with the subsequent notifications of the 49th meeting, that's notification 9 of 2023, my lords, your Lordship would see what they have done, my lords. 4 lines from the first unnumbered paragraph, my lords. I'll not bother your Lordship reading the entire thing. On the recommendation of the Council, your Lordship got a time limit. Hereby extends the time limit specified under subsection 10 of section 73 for issuance of order under subsection 9 of section 73 of the said act for recovery of tax not paid or short paid or input tax credit wrongly availed or utilized relating to period so and so. So they do not speak of anything, my lords, unlike the previous notification regarding recovery of excess refund, my lord. And similarly, my lord, the last notification, that is 56 of 2023, my lords, is concerned. It is also worded that hereby extends the time limit specified under subsection 10 of section 73 for issuance of order under subsection 9 of section 73 of the Act for recovery of tax not paid or short paid or input tax wrongly availed or utilized relating to the period so and so. So this, my lord, also does not speak about recovery of refund, my lord, which has been specifically provided for in subsection 10 of section 73, my lords. So, my lords, if your Lordship would consider my table, my lords, which takes into account 730 days, my lords, as per the notification of number 13, my lords, which I have given, my lord, at page 33 of the brief, my lord. The last date ends in 2nd of April 2024, my lords. There's no further extension so far as excess recovery of excess refund is concerned. So my humble contention would be, my lord, the show cause notice, as well as the adjudication order dated 26th of April 2024, cannot stand, my lord. It will be barred by limitations. In addition to my yesterday's submission, my lords, your Lordship would, in addition to this, I have humbly submitted, my lords, that the last date for filing of annual return has not been extended in any of the cases. They kept on extending, my lords, the other issues about adjudication orders, about recovery of taxes, about recovery of interest, but they have not, my lord, extended the last date for filing of annual returns. And filing of annual return is crucial in the sense, my lord, this 3 years is reckoned from the date of filing of annual return as per
Not from the date of filing of annual.
my lord, that
Due date.
due date notes. So I'm sorry, I stand corrected. So this due date having not been extended, my lord, up to after a particular point of time, my lord, extensions of other actions, my lord, will not stand to reason with the if you don't extend the due date of filing of returns. My lord. So that will be a second submission, my lord.
No.
And this case, my lord, is not relatable to the other cases because this is exclusively relating to refunds, my lord, not with the other aspects which my learned seniors, my lord, have dealt, my lord. And the third aspect, and my lords, and my lords, one small, my lords, aspect, my lord, is here, my lord, so far as 168 is concerned, my lords, your lordships have seen that this particular section, my lords, it contemplates three things, my lords. One is, notwithstanding anything contained in this act, the government may, on the recommendations of the council, that one recommendation is necessary, may by notification extend the time specified in or prescribed in the notification in respect of actions which cannot be completed or complied with due to force majeure, my lords. So, my lord, they say that this actions which have or could not be completed or complied with, that can be extended, my lords. But, my lords, no outer limit is fixed. So this gives an unbridled power, my lord, with the executive to approach the GST council.
So therefore, 168A is invalid according to you.
My lord, 168A is valid. I do not challenge the validity, but the power.
The moment you submit that 168A gives unbridled power to the executive, then
My lord,
you want to convey that
to that extent,
is invalid.
Lord, to that extent, my lord, because now, my lord, even in 2024, they may say that some actions relating to 1920 could not be completed, and we do it.
All right.
Lords, and so far as this writ petition is concerned, my lords, if your lordship would just permit me, so far as the limits, my lord, which was prescribed, my lord, that is Annexure 14 at page 188, my lords. I have annexed, my lord, the order
Sir,
of the Government of India.
These applications, all right, make your submission. All right.
Your lordship,
please continue. Please continue.
No, in Annexure 14 at page 188, my lord, I've given the order of the Government of India Ministry of Home Affairs, my lords. If, with my lord's kind permission, may I just place it, my lords? This is dated 25th of February 2022, my lords. They say, my lord, whereas an order of even number dated 27th of December 2021 was issued to ensure compliance with the containment measures for COVID-19 as conveyed by Ministry of Health and Family Welfare, DO number dated so and so. And
so what do you want to convey?
Lord, I want to convey, my lord, by order dated 25th of February 2022, my lord, the government, my lord, in its wisdom, has given 2 annexures by which, my lord, these actions were till 31st of March 2022, my lords. These restrictions, my lords. And if you lordship would peruse, my lord, Annexure 1, which is annexed, my lord, there, my lord, at page 190, which is relevant, my lord, which will be a part of Annexure 14, my lords, it deals with the heading, relaxation of various activities duly following the national directives for COVID-19 management under Disaster Management Act. It culls out a lot of activities which is free, my lords, including resumption of economic activity, sports and other activities, offline classes to be conducted, marriage functions and rituals, so and so. The 8th sub-item is important. All offices, both government and private, may function without any capacity restriction. So as early as 25th of February 2022, which Lord carved out a limitation of 31st of March 2022, my lords, all offices were allowed to function, my lords. So now, my lords, after that, my lord, they can't come up and say that even in 2024, my lords, we have left some unfinished work, please extend the time, my lords. And Annexure 2, my lord, similarly, they have just said that these are the modern, some guidelines, which is there, my lords, which can be taken, but there won't be any general restriction as it was prevalent from 20 and 21, my lords. So in my humble submission, my lords, in view of this refund, my lords, especially in this particular case, and section, this is, and the others, writ petition also, my lord, the limitation, my lord, ends in 2nd of April, 2024, my lords, according to the notification 13, my lords, and the subsequent notifications do not, my lord, extend so far as the limitation for claiming of excess refund is concerned, my lord. And for the other issues, your lordship may kindly permit me, my lord, regarding the powers under 73 to collect this excess refund, my lord, to challenge in a second.
Address.
My lord, your lordship may kindly grant me that leave, my lord. So, my lord, so I have only confined, my lord, my argument, my lord, to beginning from page 26 of my brief.
Well,
greatly obliged.
If your lordship will permit, if your lordship will permit me, then I'll.
Just a minute, Mr.
2 minutes, I can reply my lordship.
Is joined online.
Lordship. I am extremely sorry to make a mention here, Milord, with great respect, Milord. These two matters which my friend argued, Milord, that relate to Milord, the recovery of erroneous grant of refund, Milord. That's a completely different matter. Because unless those are there.
That is connected to 168 also.
That is intrinsically connected with the notification.
Right. That
even though the issue may be different, my learned senior.
We will see what order can be passed.
So I'll just give a small mentioning this
please do, please.
WPC numbers.
This second item, sub item, and 11. There are two parts
In fact,
of it.
it seems we want to hear.
Your lordship may give me after my senior, once he is finished, I can.
Lordship, it's a pleasure and privilege to address my Lord the Chief Justice, Your Lordship. Very rarely tax attorneys get privileged to address the Chief Justice, Your Lordships. As the first court of the state, it's our pleasure, Your Lordship. Before I begin, Your Lordships, what fell from my Lord?
Lordship,
I'm appearing in about 7 matters, Your Lordships. Your Lordship can take item number 1 in today's board first. I have about 8
Item
matters,
number
Your
1.
Lordships.
One and
Lordship, 1, 10, 13, 1, 10, 13, 19, 20, 21, and 28.
Yes.
I'm grateful, Lord Chief Justice. What fell from your Lordship about Committee of Courts? I will send a list of citations, Lordship. In my opinion, there's a string of decisions taking the view which my Lord pointed out. There is one odd case where on special facts they said one judgment of High Court won't bind on another. But otherwise in tax matters, central taxes, Lordship, uniform view. And in fact, Your Lordship, I remember a judgment of my Lord Justice, Chief Justice Chagla in 1955, saying that I have a different view, the Central Act, and therefore I will follow the other High Court. The judgment says so. So that list I will give it to Your Lordships.
Please share.
I will certainly do that. That's one. Lordship, I have small difficulty in item number 1. There are 3 notifications, Your Lordships. The notification question which we are concerned is 56 of 2023. I'll take a Lordship in a minute to that. That is dated 28 December 2023. I'm not saying it's slightly unfair on the part of for the revenue. What we have said is this notification extension has not been backed by a recommendation of GST Council. As the Lordships are aware, all GST Council minutes are published. The earlier 2 extensions have been duly recommended by GST Council. This extension, Lordship, is not recommended by GST Council. 168A specifically is on the recommendation of GST Council. The notification recites that there is a recommendation of GST Council. I must point out that, Your Lordships. The notification on the face of it says there is a recommendation of GST Council, but we couldn't find any. It is not in any public notice. We have come across some Guwahati High Court where the state has been asked to file an affidavit on this. In the present petition, we have made a specific affirmation. To our knowledge, GST Council minutes are all published. The rules of procedure require them to be published. There's no recommendation as far as 3rd extension is concerned for the state to either take oral instructions or file an affidavit on that. And the only point against me is the notification recites that is based on the recommendation of the council, but that's a factual matter, Lordship. That is not beyond the scope of judicial review. If in fact no such recommendation is there, the state cannot say, I have said in my notification, therefore High Court is shut out from that. And the lordships are already also aware. Matters of this type, when the parent statute says the delegate will do this after consulting somebody, that is not procedural, is mandatory. For example, Lordship, if the Indian Standards Act says central government frame rules after consulting Bureau of Indian Standards, okay, that consultation is mandatory. Just as prior publication and inviting objection is mandatory. Your Lordships have laid down that if the subordinate legislation laid before the floor of the House for 6 months or 3 months, that is not complied with, that is procedural, that will not vitiate it. But consultation, prior publication, recommendation, these are all mandatory, your Lordships. So therefore, our submission is the third note in 56 of 2023, dated 28 December 2023.
Yes.
Not backed by recommendation of the council is invalid.
Yeah.
As far as the first two notifications of the Lordship is concerned, not only that judgment of Allahabad High Court is there, which appears, we are office of the court, Lordship, the first instance. The Allahabad High Court judgment is somewhat exhaustive in detail. And my Lord Justice S.D. Singh is a master in tax laws. So with great respect to Lordships. So, but on this 56 of 2023, my humble request would be, Lordship, the state and the center can take instructions and tell us whether there is a recommendation of the council. If there is a recommendation, your Lordships, either they should tell us orally, or that's one point, Lordship. I don't know how your Lordship is suggesting in the earlier matter that separate writs can be filed, etc. But because what we have impugned is one show cause notice, I cannot file more than one writ petition, Lordships. I cannot file for against one assessment order, ground A one writ petition, ground B another writ petition, ground C another writ petition. I have to take all in one. Cause of action is one. So therefore, your Lordship, with respect and humility, the temptation to dispose of the batch on the first point is really attractive to any judge. Perhaps it may not be possible, Lord. May not be possible. Therefore, I was submitting your Lordship. On the first question, your Lordship may decide and set down the individual writ petition separately. Or now itself take an individual writ petition separately. That's what our submission would be. That's what our submission, Lordship. So as far as item number 1 is concerned, one ground of challenge is this third notification is without. The second unconnected ground is this is based on objection made with Controller of Auditor General. That your Lordships have held, 2 high courts have taken a view that Controller of Auditor General can audit books of accounts of the government of India and not the private assessee. Okay. And therefore, since these show cause notices are based on the objection of CAG, entirely invalid. So I don't know, Lordship, it's a completely unconnected point. You'd like to hear at this stage or later. Whatever, I'm ready with that, your Lordship. I want to show my Lord Justice Ujjwal Bhujan judgment in Bombay High Court, where my Lord has analyzed in detail. But that's a completely different point. I don't know, you Lord to take it now or next week or whenever is convenient, because too many matters, your Lordship, too many points will be confusing the matter. I leave it to your Lordship, whatever it is convenient to your Lordship. It will be my pleasure to address your Lordships, but
we'll see.
Because on that, your Lordship, these are 2 separate grounds, independent grounds. So
far as the Bombay High Court judgment is concerned, my Lord, that is pending before the Supreme.
Yeah.
No, that is different.
It's pending, your Lordship. No, I've sent the sent the list of judgments where on committee point and taxing matters. I sent my list to my colleague, your Lordship, that will forward to your Lordships. Uniform, your Lordship. I just Palkiwala's book, first chapter itself mentions this. And your Lordship's proposition is perfectly correct on that point. Particularly central statute. And SGST and CGS are identical, your Lordships. And notification in question is central notification.
Yes.
They're uniform. Therefore, so I don't know, your Lordship would like to take this up on audit objection and 56 2003 now or some other day.
You please send your the decisions which you intend to send. We will examine that and we will go through each.
No, those decisions on audit objection, I have got it readily, your Lordship.
Not audit. Please send that also.
That is there in the
decisions also on the
committee, your Lordship, that I have sent, your Lordship. I will send you that. I'll send the complete list, and your Lordship can take it from me. There are no contrary decisions. As I said, one odd judgment said if viruses of an act is struck down, that may not bind another act. My Lord Justice Lahoti in Delhi High Court says, virus is struck down, it may not bind the tribunal in another state. But that's between the tribal and High Court. We are not concerned with that. Otherwise, the Lordship's uniform view is one High Court and a central taxing statute. Otherwise, the Lordship look at it. An assessee in Patna.
That is different.
Bar by limitation, assessee in Bhubaneswar will not. That is unsatisfied in tax matters, particularly in GST or income tax. Sales tax maybe. Orissa sales tax will be different from Andhra Pradesh tax. That will be slightly different.
Okay.
So
let us see, how
Lordship-
do we in fact, we have not, after you have made your submissions as to whether we should take up other aspects or not, we shall see all the records, whether in such cases where the statutory remedies are available after we decide the matter on 168A. Such cases we shall grant liberty. In such cases where the High Court should take a decision, such points we can take up and decide.
For example, Lordship, third extension is ultra virus that cannot be decided with authority. Your Lordship will adjudicate that. The point I mentioned, the GST Council recommendation is not there.
Whether third notification was not under challenge before Allahabad?
No, not Allahabad. Not at all. Not at
That
all.
is a very vital aspect.
And the state has not filed a reply. Maybe it's a fresh petition of May. And it was filed in July. Therefore, they may not have filed an affidavit. But they can take oral instruction, Lord. There is no need for anything on that. Allahabad did not deal with that. My apologies, Lord. I should have pointed out to my Lord Chief Justice. Allahabad did not deal with that. That question didn't arise. So what I was therefore submitting, Your Lordship, is where matters involve only 168A on virus of the first two notification, that Your Lordship may, but rest maybe set down.
Because in most of the cases, 168A notification is under challenge, and in addition to that, some other reliefs have been sought. So therefore, prima facie, we are of the view that in such cases where they can avail statutory remedy, they should avail against that.
But many of them, Your Lordships, as we call in 2020 slog over disposal, the officer wanted to beat the limitation, simply pass one line on, thinking that Your Lordship will remand it back so that they can get fresh limitation. Your Lordship remembers, limitation applies original adjudication. Your Lordship, I am told in district court, when the judge is falling short of target that month, he dismisses the appeal for non-appearance and restores the next week. Restores the next week, Lordship. And so, therefore, I was submitting, Your Lordship, these petitions involving other issues can be set down for hearing. I am ready now also. I have given the case laws also. But whatever is convenient to my Lord, the Chief Justice, Lordship. That's what I was submitting, Your Lordship. Because these issues involve this. Audit objection cannot be the basis, and third extension is bad. Plus, there is a challenge to 16.2C, which Mr. Sahu gave up. Okay, but I don't want to central statute in a taxing matter, Lordship. I once told my Lord Chief Justice Chandrachud when he was in Bombay, sir, my score against the Advocate General, Attorney General is 6-0 because I lost all. Then my Lord said, in a central taxing statute, how do you get the act struck down? You show us a circular rule, we will help you. So 16.2C, I don't want to strike down because it says, 16.2C says, I will give you credit to the customer, only the supplier has paid tax because government doesn't want him out of pocket. Naturally, the supplier has not paid tax and give credit to the customer. It will be double jeopardy to the government. That's what 16.2 ceased to say. But our answer is not that. Our submission is whether supplier has paid tax or not is something you have to verify. That detail is with you. So on interpretation.
Validity of that provision has been upheld, Mr.
Lordship, yes, will be also. In some cases, it will be struck down. But more than that, Lordship, Calcutta has rated down. But the correct way would be, Your Lordships, the scheme as initially introduced thought that the tax office will communicate to the purchaser, this is the tax paid by the supplier, give an opportunity, and then 16.2 works perfectly. But once the GSTN system was not operational, government realized the difficulty and then modified it 3 years later and came up with a modified solution. No problem. All we are saying is, when I paid my supplier and my supplier issued a tax invoice, please first verify with the database available with you. I don't have access to that, whether the supplier has paid tax. Instead, blanket notice saying You are taking credit for 100, supplier is indicated as 90, 10 you pay. That is not permitted. Or in other words, burden of proof on 16(2)(c) prior to amendment in 2022. 2022, the amendment says specifically, prospectively, with the system in place, how to go about it. Prior to that, Your Lordship, there is no duty on the supplier to communicate to me, nor the department. Therefore, it is on burden of proof. Otherwise, Your Lordship, every month, all the credits taken is sought to be disallowed. And double taxation is what is sought to be avoided with GST. I'll make myself clear on that whenever Your Lordship hears on that. I'm not on virus 16(2)(c), but on the interpretation of 16(2)(c), Your Lordship. So our submission would be, Lordship, whatever is convenient to Your Lords, accordingly, I can come down also to Bhubaneswar, Lordship, Cuttack to address my Lord, whenever is convenient. But whatever is convenient to Your Lordship. That's what I have submitted. And the state should tell us whether there is if there is a recommendation for the third notification, Lordship, then this contention doesn't survive. Straight away. That's what I was submitting, Lordship.
So is this your pleading in the writ petition?
Lordship, yes. I said specifically para D.20. I specifically pleaded this, Lordship. Page 66 in item number 1.
Item number 1 is 17540.
17340, Lordship. 17340.
Just
17340. Lordship has that petition. 17340 2024. Vedanta Limited. Page 66 para D.20.
Yes. Which paragraph?
Page 66 para D.20, Lordship.
Page 63.
66, 66, Lord. 66. My Hindi is poor, Lord. Sat.
Sat. 66.
66, Lord. Oh, Hindi numbers cannot be confusing. Lord. English only is confusing, whether it is D.20. For that, it is further submitted. Notice in 56 of 2023, Central Tax at 28/12/2023 has been issued without any recommended GST council. It is submitted. Recommended GST council is mandatory to issue notice into 168A of the CGST Act. Reference. It is submitted in the absence of any recommendation of the extended period. Notice in 56 cannot be sustained.
D.20.
D.20, Your Lordship. Your Lordship got that D.2.0. Can I read it, Your Lordship? Your Lordship has got it?
Yes,
Page 66. With the Lordship's kind permission.
We are reading, Mr.
Lordship.
Yes, whether any affidavit has been filed in this case. No, not filed. But you will have to tell us. This
They can tell orally also, Your Lordship. Tell us tomorrow. Orally also.
This goes to the root of the matter. This goes to the root of the matter so far as third notification is concerned. That is vital.
Yes. The last, in the July, end of the July, it has been admitted. So I have sought for instruction and.
GST Council minutes are in public domain, Your Lordship. There is no such recommendation for this. GST Council has put it.
For 17-18, it is not applicable.
But so for 2017-18, it is this third notification is not applicable. So far as for the period 2017-18, this third notification is not applicable.
Correct. We have come to 1920 in this petition.
Your Lordship. So far as 18, 19 and 1920, Your Lordship, almost in all other cases, I think that has been only this case.
situation is that
Your Lordship.
first notification and second notification,
Your Lordship.
even Mr. Sahu is saying that he does not have any problem with that.
Your Lordship.
Only in respect of the third
My
notification,
lord,
he says that there is no application, there was no requirement.
only
But one specific
Your Lordship.
point has been taken
Your Lordship.
that without recommendation of the GST council,
Your Lordship.
this notification could not have been issued, and there is no recommendation
Your
by the
Lordship.
GST council.
Only
This goes to the root of the matter.
only for that part, Your Lordship, we may be permitted to take instruction, Your Lordship. So far as 1920. But there may be discussion. 1819, it is not applicable to your case.
1819 extended.
Not your case. ଆପଣ ତ ପୂର୍ବରୁ
31 ଅଛି ନା 31
31/3/23 notification.
56. 56.
Present batch of writ applications, into ATR. 3 notifications issued by the central government in exercise of power under section 168 capital A of CGST Act 2017, including notification number 56/2023 central tax dated just a minute dated 28/12/2023 are under challenge. Stop. Next, in WPC number 17340 of 2024, there is a specific pleading to the effect that the said notification dated 28/12/2023 has been issued without recommendation of the GST Council, which is mandatory for exercise of power under section 168 capital A of the CGST Act 2017. Full stop. You have not filed any affidavit in this case?
No, my lord. I filed an argument.
We have heard learned senior counsel and other counsel representing the petitioners and learned standing counsel or
Your Lordship, I'm standing counsel for state GST.
standing counsel for the state GST as well as AGA, learned AGA for the state of Odisha. Stop. Mr. Sridharan, senior counsel appearing on behalf of the petitioner in WPC number 17340 of 2024 has relied on Supreme Court's decision in case of Union of India versus Mohit Minerals reported in citation. to contain that in the absence of recommendation by the council, by the GST council, the notification dated 28/12/2023 cannot be sustained. Next, if it is, he has also submitted that recommendations of the GST council are in public domain. This are in public domain, but no recommendation made by the GST council is available in public domain. Recommending public domain, which can be said to be the basis for issuance of notification dated 28/12/2023. Stop. If what has been pleaded in the writ petition is factually correct, comma, we prima facie find substance in the submission advanced by Mr. Sridharan and Senior Counsel. So, next, let a specific affidavit be filed. Let an affidavit be filed by you.
To extend.
You are for whom?
I am for the central GST.
By
We have.
GST, stating specifically as to whether the said notification dated 28/12/2023 was issued based on any recommendation of the CGST council. So for the said purpose, let's this matter on these matters on 2 weeks. 2 weeks. So entire exercise is we request and council representing. That is not required to be mentioned, Mr. Sridhar. You will send the judgments on committee.
Yeah, I will. Your lordship may record it. Your lordship may consider saying he points out the standard settled position is this and give you the list of citations.
Yes, Mr. What did you want to say, Mr. Sarin?
But I beg to appear virtually minutes in the item number 6, which is writ petition number 6964/2024, my lords, and from ground number F2Q, page 38 to 49, my lords. I have set out a case.
No, these cases are different.
5, 6.
But this is where I have challenged notification number 9. In addition to that, Mullers, there is one more point which my senior Sridharan, Mr. Sridharan has pointed out in item number 1, that the interpretation of 16(2)(c), where it is a mismatch between the purchase ledger and the sale ledger. Where
we see that on the next date. We will hear you.
Yes, Malad. So they just wanted to kindly take the note of that. But I have set out the judgments at para number 10, page number 10 of my writ petition, that the matter is covered by the Honorable Calcutta High Court judgment in Suncraft Energy and affirmed by the Honorable Supreme Court. And various other high courts have taken the same position, Malads.
Calcutta High Court judgment is of which date?
That is 2nd August 2023, and the Supreme Court affirmation on 14th December 2023, Malads. So I have set out all the list of judgments at page number 10 of my writ petition, Malads. All the judgments. The Kerala High Court judgment is also there, Malads, which I have set out in the same page.
And my Lord Chief Justice, I have given it to my advocate and record with 3 citations. I don't know whether he handed over to your lordship. Otherwise, we'll send it.
Citations.
I've sent a list to him. I will give that to your lordship. There's no. Your lordship can record it also. Yeah, no difficulty. That's the correct position. That's the experience, your lordship. My Lord the Chief Justice has the experience, and that's it. Exactly. It's a privilege, Your Lordship. It's a privilege.
Pardon me, Lord, in
So, but
this
at page number 10, there are as many as 8 judgments of different high courts.
We'll see on the next page.
Please, Manoj, please, Manoj.
Well, in this WPC number 17743, but I have filed an IA to modification of the interim order. Your Lordship, in this case,
What modification?
modification in the sense, not the petitioner challenge the show demand come show cause notice. And we would ask for the notification, the date expired on 31st August 2020.
Lordship, their applicant is misconceived, statute protects them. If Your Lordship grants stay, the period for adjudication automatically stands extended. There's no need. The law provides for it. Section 75 provides for it. And even without that, Supreme Court.
All right. We'll protect you, Mr. Tom.
I need only clarification, if my seniors permit me. No question taken the period pursuing improving order adjudication without leave of court. My concern is there is no order, that is no adjudication, that is a slow cause notice. And the slow court has to complete the adjudication on 31st August 2024. If your Lordship grants stay, that I don't have any because we can proceed thereafter. Your leave is there, then thereafter the limitation part will be.
We will take care of that, Mr.
Yes, that is what my submission. Lordship
We will
record
take
that submission.
We'll take care of it. Let there. Yes, we will take up.
Interim to continue to all.
Interim order shall continue in the meanwhile.
It's a real privilege, Your Lordship, and I say it's bottom of my heart.
Thank you.
So,
2 weeks.
At 2 p.m. Your Lordship.
28th
At 2
of, no,
Sorry,
September. 2 weeks is what?
28th of August.
Lordship will come in at 2 p.m. only.
2 p.m.
Grateful. I will not make the mistake I made yesterday, Your Lordship. Yesterday I was stuck in a parter. I will keep myself free. I will not repeat the mistake. And having seen my Lord's grace, I will come first here.
Thank you.
Grateful.
Grateful, your Lord.
Item 14.
But in this case, my lord, your lordship directed to inspect the stone quarry by the mining officer, my lord. The mining officer has already visited and that sand quarry is in stone quarry is non-operational. And with regard to penalty, my lord, the sum of rupees 6 crore 24 lakhs 82,000 have been levied. And out of which, my lord, 5 crore 7 lakhs has already been realized.
No, by non-operational, do you mean it has been shut down or it is not working for the time being?
No,
Totally
not
working.
Totally not working.
Because there was a recommendation by your officer that it may be considered for opening.
Non-operational. And I will file that counter.
Then you are saying non-operational.
My lord, no, not
shut down.
My lord.
Who is here for the
There, madam has come.
On behalf of Mr. Dolly, my lord.
No, she's there.
Beg your pardon, my lord.
I'll
Kindly adjourn to.
She is behind you.
Wait. Yes.
1-4.
My lord, it is not working, my lord. I will file a counter affidavit. And with regard to recovery of penalty, my lord, from the opposite part number 8, the sum of rupees 5 crore 70 lakhs has already been recovered out of 6 crore 24 lakhs. And the balance amount notice is also issued.
It is not working, madam.
I'll go
functional.
through the counter and if required, I'll file my reply to
Time is
the.
already.
Your Lordship,
AGA
it's a-
representing the estate seeks and is allowed 3 weeks time to file counter. Place this case on 3 weeks.
Obliged.
Item number 15. My lord, item number 15, the technology matter. There are 7 items are there. I have given the list. In all the cases, I have filed counter. The similar matter are posted to 27th. My lord, I have also adjourned. Let this be given to them. I have given copy to them. Counter affidavit. But only counter I have filed in all the cases. I have given copy to them. It will be posted to 27.
Even the Indian
Yes.
Nursing Council is a party that didn't have the copy of the same.
Fourth one, my lord, WPC 15858 of 2024. In this case, my lord, I have
complied all the deficiency except the details about the principal, my lord. And that your lordship's covered by lordship's order.
Today morning also my lord passed an order.
We were waiting to ask which date should they appear.
21st. I have
Only, my
told
lord,
him.
the correction I need, my lord. The
21st.
course is only different. The course is different. And for it is a fresh NOC, my lord. That has to be corrected. The top your lordship find the renewal of NOC in respect of GNM course. It will be GNM, my lord.
So 15858 is also the same thing.
Yes.
On 21st he will
And
appear.
also it is required for fresh NOC.
He will
fresh-
appear on 21st.
21st. 2 o'clock.
21st, my lord. GNM course and fresh NOC.
Major one grant.
And it is pharmacy or nursing?
No, my lord, GNM course. Fresh NOC. Instead of renewal, it will be fresh.
This is the
My lord,
158.
18 is over. That
Huh?
18 and we have already, my lord, I have already passed on. 18.
On 21st, I will appear, my lord.
21st.
My lord.
21st. 21st. 12 letters, huh?
Obliged, my lord.
whichever cases the Indian Nursing Council is the party, let them serve a copy. They have implied the Indian Nursing Council is a party, let them serve a copy of the Indian Council. 3 cases they have implied, I find out.
Survey में copy.
Your lordship, sub-item
Just a minute. So, Mr. Which are the matters which are coming on 27th?
My lord,
No, out of this list, which matters should come on 27th?
my lord, item 1, Mahatarani College of Nursing,
Yes.
KT School of Nursing, KT School of Pharmacy, then Radharam College of Nursing, Chidanand Institute of Medical Science, Mahatarani College of Nursing.
your lordship,
Except
1, 2, 3, 4, 5,
this.
6 items.
Yes, my lord.
And
And
this 18
Principal details. So same thing.
and this 10.11 and 10.2.
That has been over past hour.
That Ma Vaishno Devi, what is the course?
That
Last
is
one, 18?
pharmacy post.
Pharmacy.
pardon your lordship, sub-item 5, that Radharaman College, your lordship. That is covered under your lordship's order. Your lordship.
No, my lord, that I have given a counter. The NOC was given on 17th for 23, 24, and he has applied on 20th in the due date, and he is now submitting. He should be covered by that judgment. I have given a counter that it come on
See,
that.
only such matters are covered
Yes.
which Mr. Mohanty certifies.
Your lordship, on similar facts, your lordship had
So,
Each case is
If he
different.
certifies, then yes.
so if
If he does not, then we will have to.
we can consider that on 27th,
Yes,
whether
my
it is
lord.
covered.
your lordship, humbly submit your lordship in the order that I'm citing, your lordship are allowed to take further applications till 31st/8/2024, your lordship. Since 31st, 27 will be closer to that, your lordship. Since
My lord,
We will take up your matter, let it come.
I'll submit a copy to him, your lordship, and also
I know the order.
He knows more than
Everything.
every one of us. Nothing matters and these DMET matters.
Just check if it is covered.
No, my lord, I have checked. Yesterday night also I have gone through his counter and
Alright.
this thing. He has given NOC like Biswas on 17th. We have directed that they have not applied for appraise. So my lords have given direction. Here in his case,
Is applied.
17th he has got the renewal. 20th before the cut-off date he has already applied for this year.
Very
And
good.
we have already given for this deficiencies to be complied with.
Your
This
case-
is not complied. He has not complied with that. That is I have given the counter. His case is not covered with that case.
Okay, so what will he do? He'll
Here on 27th it will be taken up
no,
for.
it'll be taken now, but what should he do in the meanwhile if you asked him to comply with the deficiencies?
Yes, he has already,
That date has gone or what?
date has gone.
Your Lordship, we complied within 6 days, after 6 days of
We'll
the
see, we'll hear you.
Yes.
So your counter is there, you come prepared on 27th.
Your Lordship.
Item number 38.
Last occasion, Lordship of, Lordship kindly look to your Lordship's order. Number 6 dated 6/8/2024. Good copy. Right. Either bank will come. Second bank could come. Your Lordship directed like this. List this matter such and such be taken up so and so on council representing respondent one. I am appearing to respondent one to demonstrate that Banshidhar Pradhan was ever elected as the chairman of Kalinga Institute of Mining, Engineering and Technology, Chandipada, Angul, for this court to appreciate the controversy arising out of the judgment of one single judge, which is under challenge in the present intra-court appeal in the wake of the grounds. But why your Lordship directed this? Just to recapture your Lordship memory, the copy of the judgment of the second appeal, which has been upheld by the Supreme Court, you also look to the operative portion of that judgment, which I have given last time. Second appeal, RSA number 47 of 2007. I would have copy of the This is that one. That's confusion. I can take it. That's confusion. Let's get that copy of the judgment which I have last occasion I had.
Yes, you had given.
Yes, ma'am. I'm just reading the last operative portion of the judgment. Why I'm reading? Because just to recapitulate some memory, why your Lordship wanted me that to demonstrate this, and I have already prepared that. I will demonstrate now. In the result, para 20, the second appeal is dismissed on contest, but in the second appeal was filed by another person who has claimed to be a trustee. In the result, the second appeal dismissed on contest, but in the fact and circumstances without cost, judgment of the lower appellate court is confirmed. Respondent number 4 is myself, and respondent number 5 is Gobind. Is another trustee who is no more there, he died, being found to have never ceased to be the members of the trust board, are entitled to act as the board of trustees under the deed of trust, as well as the bylaws of the trust, including the management and functioning of the trust, that is the institution. The receivership, because collector was appointed as receiver during the pendency of the civil suit. This receivership,
Indian Trust.
the receivership shall stand terminated on the expiry of 2 months from the date of the judgment. The collector Angul as receiver shall hand over the charge of the entire management of the institution to the member of the trust board, existing as on the date of handing over such charge. On the expiry of the aforesaid period of 2 months, the receiver shall cease to exercise any function in respect of the management of the institution, including exercise of financial power. The receiver shall submit account for the entire period of the receivership before this court within 3 months once. Now, your Lordship, kindly have a glance. I am demonstrating to your Lordships only the records which are also form part of the your Lordship. Repeat, sir. Lordship, kindly come to. Your Lordship wanted to demonstrate me how this Banshidhar Pradhan, who was the respondent number 4 in the second appeal, who was found to be the trustee, how he is the chairman of the trust because of the operating of the account. That is why your Lordship wanted to know. Page 9. Page 9. Lordship, look to page 9 of that affidavit I have given. This is dated 24/9/2010. While the other trustee, respondent of 5, Gobind, was alive. You also look to this resolve that both the trustees agreed upon to work together in all so and so. Last line. Sri Banshidhar Pradhan, myself, founder trustee, is unanimously elected as the chairman of the Kimet Trust. Gobind Chandra Naik is the founder trustee. He is no more, his dead, and signature of Banshidhar Pradhan, and the founder trustee of the chairman. Then also kindly come to page 10. The next meeting, that is on 3/10/2010, if you also look to the second paragraph,
towards the bottom, 1, 2, 3, 4, about 8 line from the bottom. See, Banshidhar Pradhan, founder, trustee, come chairman, explained that the principal is adamant because of the Kimet account is jointly operated. You'll also skip over, then come to page 11. Page 11. Page 11, the signature of both Govind Chandra Naik and Banshidhar Pradhan. Then you'll also kindly come to page 12. The another meeting of both the trustees, those who are found to be the valid trustee by the civil court, and that judgment has been upheld by the Supreme Court. Banshidhar Pradhan and Govind Pradhan, Govind Chandra Naik. This is on 15/11/2010. You also come to the bottom, the signature of both. Then, sir, page 13. This page 13 is another meeting at page 13. If you also look to the page 14, that is very important. Page 14, resolve that this is so far as this account in SBI and other banks. Resolve that as per clause 14 of the bylaws, a saving bank account be opened at the State Bank of India, Chandipada branch in the name of Kalinga Institute of Mining, Engineering and Technology, which shall be jointly operated by Banshidhar Pradhan, founder trustee cum chairman Kimet, and Govind Chandra Naik, founder trustee Kimet. The branch manager SBI Chandipada is advised to transfer the fund from the defunct account bearing account number so-and-so to the present account for the smooth running of the institution, and the salary and wages and other statutory dues, including other incidental expenses, can be made immediately, which has not been paid since September 2010. This is both Govind Chandra Naik and Banshidhar Pradhan, myself, founder, trustee, cum chairman. Then, sir, kindly come to page 15. The other meeting on fifth meeting of the board, that is on 25/11/2010. You'll also come to page 16. Same thing, the Banshidhar Pradhan are the founder, trustee, cum chairman. Then, sir, kindly come to page 17. I'm taking to your lordship the government order and the subsequent order passed by different banks. I'll show that. Also come to state page 17. Page 17. This is in the chamber of the Joint Secretary to Government Industry Department. Also come to page 17, annexure E/1. Undertaking submitted by the founder trustee, chairman Banshidhar Pradhan, and founder trustee Govind Chandra Naik, Kimet, as per the letter dated 21/12/2010 and discussion held in the chamber of Joint Secretary to Government Industry Department, Government of Orissa. As per the government order dated so-and-so, dated 21/12/2010, we both the trustee, namely Banshidhar Pradhan, founder trustee cum chairman, and Govind Chandra Naik, founder trustee, appear before the Joint Secretary to Government Industry Department, Government of Orissa on 27/12/2010. As discussed, we undertake to abide by the following instruction advised by the government for smooth management of the Kimet. Let's come to page 18. Page 18, Banshidhar Pradhan as the founder, trustee and chairman sign, Joint Secretary to Government sign, Govind Chandra Naik, the other trustee, has also signed at page 18. Then kindly come to page 19. After the judgment was passed in the second appeal, a direction was made that the receiver, collector was the receiver, he will hand over charge to the trustee. The page 19 is the collector's handing over charge to me. Also look to page 19. 15/1/2015, handing over the charge of the entire management of the institution Kimet to the member of the trust board of so-and-so in pursuance of the order dated of the Honorable High Court of Orissa, Cuttack. We have this state in the afternoon, made over and take over the assumed charge of the entire management of the institution of Kalinga Institute of Mining, Engineering, Technology, Kimet, in the district of Angul. Collector and DM District Magistrate Angul has signed, and Banshidhar Pradhan has signed. You also see the cash saving bank account, fixed deposit. Next page, you'll also see different deposit in the different bank, HDFC, SBI, Eco Bank. These are the next page 20, which was handed over to the present petitioner, present respondent number 1. Then, sir, kindly come to page 21. A letter was addressed by the collector of district magistrate on 19/8/2019 to the present respondent 1, Banshidhar Pradhan, founder trustee. Collector has addressed this letter. See, Banshidhar Pradhan, founder trustee cum chairman Kimet at post Chandipada district Angul. Submission of monthly statement of account and expenditure of income before the collector. This is page 21. Then kindly come to page 22. Different banks have addressed this letter, page 22. 23/11/2020, Office of the Collector, District Magistrate has addressed this letter to different bank manager. That means including ICICI Bank, Kotak Bank, HDFC Bank, SBI, Chendipada, Eco Bank, Ongur, and other banks regarding financial transaction of all bank account of Kimet Chendipada with reference to the letter that it's so. I am to say that this letter is hereby withdrawn. Earlier it was said that nobody will withdraw that, and that was withdrawn by the collector. That was done granting liberty to the present respondent number 1 to this founder trustee come chairman to deal with all the accounts. Then you also kindly see page 23. This letter has been communicated to the present respondent 1, Bansidhar Pradhan, copied to Sri Bansidhar Pradhan, founder trustee come chairman, Kimet for information necessary action. Then sir, kindly come to page 24, government order. That is at page 24, the additional secretary to government in the employment and technical education and training, who is the apex body so far the technical education is concerned, addressed to the principal Kalinga Institute of Mining Engineering, subject regarding smooth function of the Kimet Chendipada and operation of the institution fund to meet the day-to-day expenditure and pertaining to the function of the diploma institution, inviting a reference to letters answer on the subject cited above, and directed to say that after careful consideration of the judgment dated 18/11/2014 of the Honorable High Court, subsequent handing over the charge of the entire management of Kimet Chendipada by the collector and district magistrate Ongur, com receiver, to abide letter number so-and-so dated 15/1/2015 in pursuance of the aforesaid order of the Honorable High Court, and taking over the charge of the entire management by Bansidhar Pradhan as founder trustee cum chairman of the Kimet, and keeping in view the order of the SDJM Ongul passed in GRK, so and so, taking the interest of the institution in general and student in particular, it is decided that the above mentioned trustee, that means Bansidhar Pradhan, in general and student in particular, it is decided that the above mentioned trustee is allowed to operate the bank accounts of the institution subject to condition that proper accounting and transparency in managing of the institution funds should be strictly followed. Then, sir, kindly come to page 25. 25 is the State Bank of India.
What is the dispute about?
Sir, now the bank has come forward because the Honorable Single Judge had directed that you must disperse because that bank fixed deposit receipt.
Who are the trustees?
Trustees now the Bansidhar Pradhan, and after the death of Govind, now my learned friend's client, he has become the trustee. And they have already passed a resolution that has been registered, and they are operating there.
What they? He is only left.
He is only two persons.
How many trustees were originally there?
That originally belonged that seven trustees. Now, after the judgment of the second appeal, this honorable court held that there are two trustees, those who are continuing. Other trustees are not there.
Not there means how?
But the one is dead, the others have already left, and others are not found to be the genuine trustees.
How?
That is
no question of genuine. There were
Right.
7 trustees.
Yes, sir.
What happened to the rest 5 or rest 6?
Because rest 5
you are representing the second trustee.
he has been now newly inducted after the death of Govind.
In the second appeal,
Who inducted you?
the existing trustee.
Only one person.
Yes.
So there was only one person
No,
surviving.
there were two trustees.
One died.
One died without taking
Judgment,
charge.
second appeal.
Without taking charge, second appellate court found there are two trustees, Govind Chandra Naik and Bansidhar Pradhan. After the second appellate judgment, collector was directed
Who is the author of the trust?
Author of the trust. But Bansidhar Pradhan,
Where is that?
that trust deed, that is judgment of the second appellate court. You also kindly look to that. What is the subject matter of that dispute that has been already adjudicated there? Well, may I read that judgment?
No. Whether that deed is there here.
Yeah, that trust deed. Trust deed. Now, present trust deed which he has been inducted, that you have already enclosed that.
That can't be.
The original trust deed you want, not small.
There can be one.
Then grant me some time, I can produce that. The original one. I can produce it. That is not part of the record. That is part of the second appeal judgment. But the civil court will ultimately, after adjudication, clearly held that respondent number 4, that means Banshidhar Pradhan, and respondent number 5, Govind, who is no more, they both are the trustees.
Valid trustees?
Valid trustees of the trust.
Those are the trustees. If the trustees die, then which provision of law shall operate
Under the Trust Act.
under the trust?
That is section 20. I'll address to your lordship. That in terms of that provision, it has been done. I'm sure that your lordship may kindly allow me time. I'll produce that. That is in terms of the Trust Act. The other trustee has been now replaced. The person who is dead in his place. Now the present trustee has been inducted.
And I have given that affidavit, I've served copies, I have given that affidavit of the new trustee, as well as induction of the trust.
Trust. The registered document.
Who are you?
Well, I'm just now the new trustee.
But otherwise, what do you do?
Burton form.
Somewhere I read you are an employee of this
No.
driver.
No. They say whatever they like, they want to say.
They can say anything.
No, that is not the question. The question is that who shall substitute
Yes, sir.
in case the trustee, one of the trustees or
Died.
many of the trustees, some of them die or leave or whatever, that will have to be seen.
Must be there in your deed.
That your lordship,
That must
although
be there
that is
in the
open
trust.
for lordships to ask me the question, I must also answer to your lordship. But here is the question, my lord. The sole question for consideration, all the bank have now, they have already allowed so far the founder trustee, and that was the subject matter of dispute in the
Second appeal.
division bench, not only second appeal. You also see, I have given the copy of the judgment order, where this honorable court has page 34, a division bench of this honorable court, page 34. Kindly see page 35, who is the petitioner? Kalinga Institute of Mining, Engineering and Technology, KIMET, represented through its founder, trustee cum chairman, KIMET Trust Board, Mr. Banshidhar Pradhan, the petitioner. You also look what was the order passed. That is at page 36. On 29/10/2019, hard Banshidhar Pradhan, because at that time COVID was continuing, hard Mr. Banshidhar Pradhan, page 36. Does you get it?
We will examine, Mr.
Yes. Hard so-and-so, and direction was made to Revenue Divisional Commissioner to explain that why the interest has not been paid. Then you also see the next page, page 37, page 39, at page 39. Pursuant to the order of this court dated 29/10/2019, Sri A.K. Naik, Additional Secretary to Government and Disaster Management, Khurda, and so-and-so, Tahsildar, Chandipada, OP number 4 were present. Collector was
We will
also.
examine, Mr. Let us understand what happened to
Yes,
other
that
trustees,
what she is asking, I certainly will answer.
whether
Right.
after the death, only you and
Right, sir. Right. That is in terms of the Trust Act we have done it. But I'll show you, Lordship. That's right. But another thing, Lord, is a very clear question of law.
Sir, I'm challenging the maintainability of this writ application. Because I'm challenging. Sir, there were two cases, two writ petition filed. One by my learned senior, representing the trust to Banshidhar Pradhan. One by the other newly inducted trustee, that is me, Sumeran. In both the case, orders were passed. They have challenged the writ appellants, both the appellants. My senior Mr. Rotha's client is the bank. My senior Mr. Rao's client is the interveners in the writ petition of my learned senior. They have questioned that single writ petition. They have not challenged my writ petition. So when the two orders have been passed, one writ appeal is filed, whether that writ is maintainable, I have got the judgments to show before your lordship.
No, we shall not interfere with the other order. If there is one writ appeal and there are two orders,
yes,
then we can entertain only one.
So, my lord, once the second order is not challenged, similar order was passed. Second order also was not.
According to you, because second order was not challenged, therefore this writ appeal is not maintainable.
Yes, my lord,
No,
there are judgments to that. I can demonstrate.
There cannot be any judgment.
My lord, there are judgments. I will show.
Okay, sir.
I will
You examine it.
try to
You please
convince your
examine.
lordship.
Examine.
I'll try to convince your lordship.
I will-
Subject to what your lordship decide, but I'll try to convince your lordship.
I will pardon my lord.
the respondent wants.
My only concerns of mine, so far all banks, including State Bank, ICICI Bank, HDFC Bank, all have done it. And judgment was passed by this honorable court where the additional secretary, they also decided that he's the founder trustee and everything. Now, how the bank now held up my entire accounts saying that the fixed deposit, that form, the entire ground they have taken that the form that was not available, that is available in the office. Then the honorable single judge directed the collector to make an inquiry. And the collector filed an affidavit through the Tahsildar and said that has not been handed over while handing over that charge to Vanshidhar Pradhan. This receipt has not been handed over. So therefore, in terms of the guideline issued by the RBI, the honorable single judge has directed that you must, master circular of the RBI, that you must give a duplicate one. And for duplicate one, you are required to make a publication in the newspaper. You have to give all other requirements you must satisfy. That we have already done. Now they are holding, so far the bank is concerned, bank has filed this application and on some villagers have come forward, this is a public.
What is the amount?
Amount about 3 crores or something.
At present, it is about 4 crores.
3 crores was original.
My read application, my lord.
Bank may not be having that much funds.
They may have
I'll file a reply application, my lord. In my writ application, after the order was passed, which has not been challenged by them, I filed an IA that I have deposited the requisite documents. Kindly provide me. The bank there considered before the honorable single judge that yes, we are examining the matter, we'll do it immediately. And that order has not, I have contempt, that contempt has come up before.
No, that order also he has enclosed and he has given to alerts.
And they have not challenged that order. And that contempt is there on the boards, my lord, today, because along with the writ appeal, that contempt was called for. That contempt is there in my lord's board.
Anyway, let's make, because today's no time.
I may be allowed some time to file a reply affidavit because the resolutions which are annexed and filed today before my lords were passed on a date when both were not the member of the trust. They were removed and the second appeal and the civil litigation was continued. The civil litigation commenced in the year 2002 and it is concluded in the year 2015. And the resolution, all the resolutions of the year 2010. And the first one is the copy of Annexure D/4, which is the interpolated resolution. That is my specific affidavit. Therefore, I require a reply affidavit to file.
Have you been instructed by the interveners?
I'm the appellate. I'm the appellate. Because I have come to, I just now I've examined and what is the date of the second appeal judgment. It is 2015. When the suit was instituted, I gone through the judgment.
The bank does not have any interest.
No, bank has no interest, but bank cannot release the money to a person who is not competent.
We will see that.
And they are saying that Govind Naik has passed a resolution now, my lord. This is the document for which
All right, what is the amount?
It is 4 crores at present, my lord.
4 crores we will direct you to release to be deposited in some account of the High Court.
Yes, my lord. That we have no objection. That we have no objection. But here it is, they are saying that the resolutions are passed, but this is
not
for which bank is
objected.
To what extent the bank is going to, you will also see this.
We will deposit before my lords.
Yes.
We have no objection to deposit, but we cannot release the money in favor of a person who is not competent to operate.
All right.
I may be permitted to file a reply.
I have also reply. When was it filed?
Today. So, my lord, I have also filed an affidavit. I have served it.
As requested on behalf of the applicant. 2 weeks time is allowed to file. Reply to the affidavits filed on behalf of the respondent.
Private respondent.
Respondent 1 and respondent 5.
Respondent number 1 and respondent.
Beg your pardon, my lord.
Item number 49 today fixed at.
Yes, pistol.
Fixed at 2 p.m. Yeah. Tuesday at 2 p.m. my lord.
52 is the 2 p.m. That's the TT. Teacher eligibility.
Another item 47, my non-senior friend is there, myself is there. Mr. Soding had made a mention yesterday that he will be absent. Can you also keep it to 10 days after so that 10 days after? That is item number 47.
47 as requested. When do you want?
10 days after any time.
My lord, item 21, my lord. It is taken up Tuesday also at 2 p.m. my lord. Item 21 bail matter.
Bail.
Tuesday,
Item, just make a mention.
Yes,
You have
item
criminal appeal,
21.
bail in criminal appeal.
Yes, madam.
Yes,
It will come on Tuesday. You can point that out at 2 p.m. We will take up that matter on priority basis. What is your period of incarceration?
I have
That's almost 10 years.
11 years.
Take up your matter at 10.
Only one point is another appeal is pending, you also may take out along with that.
Give the number.
93 of 2021.
All right. Have you filed your objection?
Lordship, Lordship directed, I have written a letter because if
All
they
right.
don't appear, Lordship can pass that on.
So we will take up your matter on Tuesday. You just make a mention at 10:30 and we may take up the matter at 10.
Yes, Lord, I don't object to that, only along with criminal appeal number 93 of 2020. Similar co-accused persons, once your Lordship will dispose of all, I not on piecemeal basis, Lord.
With your lordship.
93 of 2021.
2021.
Because in one case, persons have been granted bail by the Supreme Court out of the same Lordship.
Our matter lordship fixed at 2 o'clock. Our matter was fixed at that.
Item 58, my lord, LLM course admission. Admission process already started. Item 58, may I pray?
LLM.
LLM. And Bhubaneswar. It was before honorable single judge. Now subsequently state council pointed out it is a division bench matter. That's why it has come. It was earlier before honorable single judge. It was heard 2-3 occasions. Subsequently state pointed out it is a division bench matter. That's why it has come to your lordship.
So make a mention on Tuesday in the morning.
This process has started already. It is today's list at 58.
You cannot take up the matter. So do you take up the matter today?
No.
You can
60.
do it. If,
Sorry. Monday or Tuesday.
Monday you make a mention at 10:30. Because these are admission matters. We will take up the matter. Whether affidavits have been filed.
Yes. Affidavit.
Just make a mention.
Yes, state